And we're now on the record. My name is Scott Dancer. I'm a videographer retained by Reliable. This is a video deposition in the United States Bankruptcy Court for the District of Delaware. Today is November 22nd, 2021, and the time on video is 9:33 a.m. This deposition is being held remotely in Re Boy Scouts of America and Delaware BSA LLC. Our deponent today is Timothy Kosnoff. All counsel will be noted on our stenographic record, and our court reporter today is Karen Friedlander, and she'll now swear in our witness.
Raise your right hand, please. Do you solemnly swear that the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, 1 minute before you start, I just want to have the right view because I don't have a speaker view. Mr. Patterson, would you just speak for a minute?
Yes, good morning. Good morning.
Yeah, I'm not sure you're not showing up. I'm going to have to put on gallery.
Hey, Tom, if you don't mind, can I just make one remark?
It is.
Okay, I'm ready.
So this is David Wilkes for the witness. I just want to point out the witness has, he's experienced some hearing loss, so I just ask everyone keep their voice up and enunciate as clearly as you can. That will make today's proceeding go much smoother. Thank you.
Good morning, Mr. Kosnoff. My name is Tom Patterson. I'm a lawyer at KTBS Law, and I represent the interests of the Zalkin Law Firm and the Fowl Law Firm. Are you familiar with those firms?
I am, and it's nice to meet you, Mr. Patterson.
It's nice to meet you, Mr. Kosnoff. Mr. Kosnoff, are you in the room alone?
Yes, except for my dog.
Thank you, Mr. Kosnoff. Have you been deposed before?
Yes,
And you have taken depositions before?
many.
So I know you're familiar with the rules, but I'm going to ask you questions. I need your verbal oral answer to those questions, not just a gesture. Other attorneys may as well have questions. And it's helpful if we don't talk over each other. I will try not to interrupt you, and I request that you do your best not to interrupt me.
I understand, and I practice primarily in state and federal courts. I've never testified in a bankruptcy court, and I'm not familiar with the local rules. So I'll leave that to my attorney, Mr. Wilkes.
Of course. And if you don't understand the question,
Apple, Google, Microsoft, Facebook. And then if I click
please
next,
mute.
it asks me to put in a URL.
Please mute.
Now, if I put in sam.hershey@white-case,
I'm sorry.
something
Excuse
different.
me, it's the court reporter. Someone's speaking. They need to mute their microphone. Thank you.
Thank you, Madam Court Reporter. So if you don't understand a question, or if it's not clear, or you don't hear it clearly, please ask me to repeat it or restate it, and I will be happy to try to do so.
Good, and I appreciate your keeping your voice up. I can hear you just fine now.
Thank you. Mr. Kosnoff, are there any circumstances that prevent you from giving your best and truthful testimony today?
No.
Thank you. Mr. Kosnoff, you are a practicing lawyer.
Yes.
In what state are you licensed to practice law?
I'm licensed to practice in the state of Washington. I've gone inactive or retired in the state of Illinois, where I was admitted, and I've also gone on inactive or retirement status in Oregon, where I was also admitted.
How long have you been practicing law?
I was first sworn in September, October of 1980 in Chicago.
And is there an area of the law that you have focused your attention to over the years?
It's changed. When I was in law school, I wanted to be a criminal defense lawyer, and I pursued that and was a criminal defense lawyer in the public defender's office in Chicago. I tried my hand at a...
Sorry, there was a screen freeze. Sorry. Excuse me, Mr. Kosnoff, there was a screen freeze. Last thing I got was that you were in the public defender's office.
Right, in Cook County. Anyway, by 1986, I decided I had had enough of Chicago and I wanted to move to a beautiful part of the country. So I moved to Washington State, took the bar, passed, was admitted in, I believe, the fall of 1986. I practiced, my first job in Washington was as deputy or senior deputy prosecuting attorney in San Juan County, which is comprised of a group of islands in Puget Sound. And it was a very remote area, and I handled the misdemeanor caseload and handled a few felonies. But mostly that was my practice. I was there for roughly 2 years, and then I needed to earn a better living. So I moved to Seattle, opened.
I'm sorry, you're breaking up again, sir. You moved to Seattle?
There's a terrible echo.
Coming from me.
It wasn't before, but it is now.
I'm sorry, I don't know who was speaking.
That was David Wilkes.
Thank you.
Well, I apologize. Maybe at a break, I can check my router and see if by moving location in this unit, I can get a better signal, but I'm showing that I've got plenty of signal. Anyway, so I moved to Seattle, suburban, moved into a home in unincorporated King County and commuted down to my office in Seattle. My practice consisted of appointed public defender cases, where the county public defender had a conflict. So I was on a panel and I'd get called and I would handle those cases in misdemeanor, juvenile, and felony courts. Later on, I was invited to become a member of the Criminal Justice Act panel, where I handled conflict cases in the federal courts because the federal defender couldn't represent multiple defendants in the same proceeding. I had a small solo suburban criminal practice, and so I would also handle DWIs, drug possession, and also handled on an appointed basis 2 or 3 murder cases.
There's an echo again. I don't know if everybody needs to mute themselves while he's speaking.
Madam Court Reporter, it's Cameron Moxley of Brown Redneck on behalf of the coalition. I suspect the echo is actually coming from you, Madam Court Reporter. It seems to be that when you speak, we all hear the echo as well. Maybe because there's multiple devices hooked to your account. I'm not sure.
You were just echoing on my end. Did anyone else hear the echo?
No.
Okay, let's try it again. I don't know. I don't have anything hooked up around me. Go ahead, Mr. Kosnoff.
I'm sorry.
You may proceed, Mr. Kosnoff.
In 1995, a young man came into my office and told me a story. He was 17, how he had been raped over a period of about a year by a high priest in the Mormon church. And I asked him why he called me. And he said, well, I was looking through the yellow pages and I saw your ad, and what was done to me was criminal. And I figured I needed to talk to somebody like you. At that point in my life, I had virtually no experience in the civil justice system. But the story was just compelling. I thought it was an extremely rare case. I couldn't imagine that a church would knowingly recycle a violent child rapist. But they did so over years.
I'm sorry. I'm sorry. There's a problem on my end and I don't know what's going on. There's an echo.
Yes.
Anyone else hearing the echo?
Yes.
Is it just, okay, so it's not just me?
I heard it over the last 15 seconds or so.
Yes. Okay, I don't know if, it looks like everybody's muted, so. I'm gonna stay muted as well, unless I have a problem.
I don't know if I can control my mic, but in any event. So his name was Jeremiah Scott. And I, along with my office mate, who was a construction defect attorney, brought a case against the Mormon Church in Portland, Oregon, and litigated against the Mormon Church for 5 years. And that was my first introduction to the world of child sexual abuse, civil actions on behalf of child sex abuse survivors, and a long journey into the world of the LDS Church and the way it treats or fails to treat pedophiles in their midst. So that case settled in August of 2001 after 5 years of litigation that took me to a half a dozen states around the country, where I uncovered a trail of Mr. Curtis's, the perpetrator's victims, and that the Mormon Church had known about it and had not reported him to the police and had actually covered for him. That case settled in August of 2001 for $3 million. It was not a confidential settlement. And at the time, it was the largest, to my knowledge, reported settlement of a child sexual abuse case in the country. After that, there were larger settlements, but it got attention in major media, and additional victims of Frank Curtis read that and contacted me. And so there was subsequent litigation against the Mormon Church with respect to Mr. Curtis. The timing of that was also coincidental, because 5 months later, in January, February of 2002, Judge Constance Sweeney in Boston ordered the Boston Archdiocese to turn over its priest files, and there were hundreds. And for the first time, the world could see that these were not isolated incidents in the Roman Catholic Church, but were part of a long historical pattern of covering up for Catholic priests, moving them to new parishes, foisting them on unsuspecting parishioners. And
I'm sorry, Mr. Kosnoff, you have to go back. It froze again. There's a long historical pattern of covering up for
child abusers in the Roman Catholic Church, principally priests, but also other religious. Before that, the church's public relations machine churned out that lawyers were exaggerators, that it was a blip here or there. But now those papers and the best follow-up investigative reporting by the Boston Globe transformed this into a global story that went on for years. And here I was a solo practitioner, and I had successfully represented a client and had determined that I didn't want to handle any other kinds of cases. And so I announced that I was representing survivors of child sexual abuse and no other cases. Now, there were other law firms that had come before me that were generalists in personal injury, and but I created a little amateurish web page in the early days of the web, and the phone began ringing, and within a matter of 6 months, I had way more clients than I could possibly handle by myself. Many of them coming from Washington State, most of them, particularly the Spokane diocese, some from the Archdiocese of Seattle. And they were identifying priest abusers that had never been previously identified. And so I undertook to discover as much as I could about these priests, where they'd been, what the bishops knew about them. And it happened one day I was in court and I met Mike Pfau, and we had coffee and talked, and he had several cases against the Seattle Archdiocese, and I did. And he proposed that we work together, form a joint venture with his law firm, which was at that time Gordon Thomas Honeywell. And together we represented, over the next 5-7 years, hundreds, if not thousands, of abuse survivors, and not just against the Catholic diocese, the Mormon Church, Salvation Army, Jehovah's Witnesses, Big Brothers Big Sisters, and the Boy Scouts. So I had made.
I'm sorry, it's the court reporter. You froze after Jehovah's Witnesses.
And other religious and secular organizations, including the Boy Scouts of America. I didn't have any Boy Scouts of America cases, but I had studied the Boy Scouts of America, had read about cases that other lawyers had brought, and I came upon a book that had been written, published in 1993, called Scouts Honor Sexual Abuse in America's Most Trusted Institution. It was a remarkable book, and it was based upon approximately his review of 3,200 perversion files, as they're called today, but back then they were called ineligible volunteer files. And these were the top secret files that were kept by the Boy Scouts of America, which reflected the individuals that they had been quietly removing as scout leaders over a 20-year period of time. And I contacted that lawyer and learned that he had gotten them in unredacted form because in a series of motions to compel and subsequent depositions, it was revealed that the Boy Scouts lawyers had not been forthcoming about the number of files that they had. And in frustration, the judge ordered the Boy Scouts to turn over that collection of files to him, unredacted. He had them. That was the last Boy Scout case that he handled. It settled, and he had destroyed the files. But he said there was a reporter in Washington who had made a copy of those files. So in and about I can't remember exactly, it might have been in the early 2000s, I found that reporter. He was no longer working for the Washington Times. And he told me the book was kind of a disappointment. It didn't sell very well. I told him I thought it was one of the most important books I'd read. And did he have the perversion files still? And he said, well, it's funny that you are calling, because we were about ready to clear out all those file boxes from the spare bedroom because we're having a child and we need it as a nursery. And I was going to have them shredded. And I said, please don't do that. I said, how about this? We're going to hire a service to set up high-speed scanners in that bedroom, and we're going to digitize all those files. And when we're done, I'll give you a copy in digital form. But what do you say about that? And he said, fine. So we did. His set was eventually destroyed, but I had the only unredacted set of approximately 3,200 files outside of the possession of the Boy Scouts of America. So with that, we began taking a closer look at the Boy Scouts of America. I'm
sorry, you froze again, sir. I'm sorry, sir, you froze. So with that, we began taking
a closer look at what was in these files. And I, along with staff members, began reading the perversion files. And I believe there were over 100,000 pages, and abstracting the information in those files onto spreadsheets so that we could analyze them a little better. And that took a period of time. And during that period of time, we were hired by two brothers that were sexually abused by their scout leader in the Seattle area. And we filed a lawsuit against the Boy Scouts, the local council. And through discovery, we were able to obtain, I believe, another 2,500 of the files. At the conclusion of that case, which settled in about 2006 or 7, after we had been forced to litigate the issue of the perversion files to the Washington Supreme Court, the Washington Supreme Court ruled in our favor that the files were relevant and discoverable and admissible based upon our theory of liability against the Boy Scouts of America, which was simply that they knew or should have known and had a duty to warn or protect Scouts. There were other cases that came in. The Boy Scouts settled those cases. I was at a conference and was asked to speak about these files, and I did. And I was contacted by some lawyers who were litigating a case in Oregon and asked if they could have access to the files and my work product so that they could demonstrate to the court why the court should order the Boy Scouts to release additional files, and approved, or at least ruled, that their theory of the case could go forward. So that was the case that Paul Monis and Kelly Clark won an $18 million verdict against the Boy Scouts in, I think it was 2012. The Boy Scouts argued against the public release of those documents. I had already had the documents, many of the documents which were in the public domain. I provided those files to the Los Angeles Times investigative team, which spent a year reviewing them and analyzing them and reporting on them. And then the Oregon Supreme Court ordered that the additional files that were turned over in the Oregon case could also be made public. So by 2012, the cat was completely out of the bag, so to speak. By 2013, I was about to turn 60. I had grown tired. Mike and I had tried several cases to verdict. I can't actually even recall how many that we developed and settled literally on the courthouse steps. I also took on cases in places that, in retrospect was a fool's errand. Brought cases against the Mormon Church in Utah and in Idaho. And I was aggressive and tireless, but age catches up with you. When you turn 60, you realize that life is not unlimited. So I determined that I was going to scale back and move into retirement. But I made commitments to many clients, and it took years to work off the existing caseload. In 2014, I ordered the construction of a 55-foot sailing yacht. It was delivered and commissioned to Annapolis in August of 2014. I sailed it to Puerto Rico in March of 2015 and was resident in Puerto Rico, living on my boat, sailing around from
I'm sorry, you cut out again. You were living on my boat?
Yes, there's been some question about being evasive and mysterious. There's no mystery when you live on a sailboat. It's mobile. So I had a mail forwarding address in Texas that would scan my mail and email it to me. And so I could work wherever I had cell service and an internet connection, which is most places in the Caribbean. I had an office in Seattle on Pike Street. I had closed that up in 2014.
Excuse me, is there a question pending? If there isn't, I'm going to object that the question must have called for a narrative response, because I don't think there's a question pending at this point.
I'm sorry, who's speaking? Who is speaking? I don't.
Oh, I'm sorry, Mr. Schivoni.
Your full name,
Tancred Schivoni?
please?
O'Melveny and Myers?
Thank you.
Well, maybe I can help speed this up. I have a 2019 on file.
Well, hold it. There's actually supposed to be a question and then an answer. It's not as, we're not doing.
Then let me ask a question, Mr. Kosnoff.
Yes.
You've recounted the history of how you became involved in Boy Scout litigation.
Some information about being recruited by Compass before we initiated the litigation.
Something. I'm sorry. Could someone mute them?
Could I ask you how you came to be involved in representing claimants in connection with the Boy Scouts bankruptcy?
I had wrapped up my cases and was anticipating being retired from the practice of law by the end of December 2018. I don't recall exactly where I was located. It could have been in the Bahamas or Fort Lauderdale. I just don't remember. But I read an article in the Wall Street Journal that was reporting on a leaked email that came from the Boy Scouts of America's executive. And in the article, it mentioned that the Boy Scouts were contemplating filing bankruptcy, that they were facing a couple of hundred lawsuits, and it was under consideration. I realized at that point that it was more than a consideration, that they were going to be moving into bankruptcy, because I knew having read all of the perversion files, that there were not 200 or 300 victims of abuse in the Boy Scouts of America. There were hundreds of thousands, perhaps 1 million or more living victims of Scout leader abuse in the Boy Scouts of America. It was a simple matter of arithmetic. There was at one time 50,000 of these files. They destroyed the bulk of them in the early 70s. What I saw were the files that hadn't been purged. And that comes directly from the testimony of the man who was responsible for those files, Mr. Ernst, who's now retired, I believe. In any event, I had worked with the Eisenberg Rothweiler firm principally. Well, I'd worked with Stuart Eisenberg and a younger partner, Josh Schwartz. I had referred a couple of Boy Scout cases out of New Jersey to them. They did a good job, got a good result, and I liked them. So I had thought that because of the size of their firm, I believe they had 13 attorneys and staff members and so forth, that they could, that they were a good fit. Stuart had litigated sexual abuse cases against the Catholic Church in Pennsylvania, which was not easy. But I was impressed that even though he lost, he kept trying. And so he had a background. And Josh was also interested in these cases. So I called up Stuart and I said, Stuart, we need to talk. So I flew up to Philadelphia, and I don't remember where from. I might have been back in Puerto Rico. And we had a meeting, and I showed them the article, and I related to them what I just related to you, that I believe that there are perhaps hundreds of thousands of victims of abuse in scouting out there. And what the Boy Scouts were planning on doing was running a pre-packed Chapter 11 bankruptcy that would result in hundreds of thousands of men losing their legal right forever. That the Boy Scouts were seeking a national discharge, and that if we didn't get the word out, these men would never have an opportunity for justice. So they agreed, and I said, I have no idea how you communicate with this population of victims. Stuart said, there's an attorney named Andrew Van Arsdale, and he's very good at producing television commercials and Facebook. He's got the technology. He comes from that background, and he said, let's call him. And so we did, and I explained it to Andrew, and he said, I'm in. So that was in roughly January of 2019, possibly early February. And we started out slowly. The agreement was that Eisenberg, Rothweiler, and Kosnoff would front the outlays for the television advertising and Facebook and whatever, but that Andrew would manage it. He knew how to get the most bang out of the buck. So we'd get remnant ad time on different cable stations. I think he had successfully negotiated a deal with Dish Network, so we were on satellite. And it started out slowly. Before we began, I had maybe 100, 150 clients who I had initially thought that I might be able to get recovery for them, but I had to withdraw because I didn't believe that I could commit to them. They were in states where the statute of limitations were unfavorable, and but that if that ever changed, they might have an opportunity to pursue litigation against the Boy Scouts in the states where they were abused. So I have to go back and look at the numbers. Andrew's probably better at this, but I would say by May, we had 500, 600, 700 clients. The calls would go in through Andrew's call center in Billings, Montana, where he had a staff of paralegals and legal assistants and social workers who took the calls. They had a system for intake, review, follow-up, and it eventually led to the creation of a memo which summarized the essential information, including a narrative of the abuse, where it occurred, when it occurred, the age of the client at the time, and any other information that they might have. Sometimes they could remember, sometimes they couldn't. Some of these men were raped when they were 7, 8, 9 years old, and they're now 75. So we got the information that we could, and you always want more, and eventually you can find it in the course of a litigation. But we weren't in a litigation. We were in what was going to happen, and eventually did, which was a Chapter 11 bankruptcy. At one point in the spring, early summer of 2019, we had hundreds and hundreds and hundreds of names.
I'm going to object to form as the question. There is no question pending. We're just really getting an opening statement, an open-ended narrative response, and it's improper, and I object.
Kosnoff, let me ask you a question.
The
Mr.
coalition
Kosnoff.
second.
Sorry, one at a time, and I don't know who's speaking.
Pardon, it's Cameron Moxley of Brown Rudnick on behalf of the coalition. We second Mr. Schiavone's objection. Thank you.
Mr. Kosnoff, you referred to an agreement that you reached with Mr. Van Arsdale and Mr. Eisenberg with regard to the sharing of expenses and responsibilities. Was that agreement memorialized in a writing?
Possibly an email, but these were handshake agreements between people I trusted. And in fact, that's what happened. We were all responsible for our own law firm overhead. The monies that were advanced were costs of the project to be used to purchase television ads.
Was there any agreement among the three of you with regard to the responsibilities each of you would have with respect to the components of the representation?
Yes.
What was that agreement?
Objection.
That the initial intake and screening and summary preparation would be done by Mr. Van Arsdale's law firm. That work product would be distributed to me and to Eisenberg Rothweiler. And I became part of the screening or vetting process. I personally reviewed, I believe, over 5,000 of these intakes until they came in such volumes that I couldn't keep up. Eisenberg Rothweiler expanded their staff, brought in contract paralegals, legal assistants, and so forth to start going through these summaries and following up with clients to gather additional information to determine if they had criminal histories, if there was anything that was in there that suggested that the claim might not be meritorious. I was doing the same thing. And, you know, there were times where I would read something and, you know, it needed more information, I felt, but sometimes that information just wasn't available. Other times there were things, I mean, nothing about what the person was saying not being true, that they had been sexually assaulted. I've interviewed thousands of abuse survivors, and I could tell by reading these that, you know, they were credible. There were some where they just weren't meritorious because the Boy Scouts weren't responsible. Some other entity was. And so that needed to be identified.
What would be the other entity that would be responsible for the claims in those cases?
Well, pardon me, counsel. Madam Court Reporter, I objected to the last two questions. I think others on this Zoom heard my objection, but it's not reflected in the real time. I just wanted to make sure the court reporter can hear me. And if those two objections could be please noted for the record.
I did not hear them. I did hear you speaking that time.
Okay, very good.
So
Please do
there has to be a pause. If there's two people speaking, it cuts you out. So thank you for bringing that to my attention.
Thank you, Madam Court Reporter.
There were
Extra form, by the way, sorry.
There were some claims that suggested that there was perhaps severe mental illness or schizophrenia. Doesn't mean that the claim was false, but the narrative was almost incomprehensible. So those would get sent either back to Andrew's team, or they would get sent to Stewart's team, which was headed up by a lawyer named Rita, and they would take it from there. Sometimes some of the dates didn't line up, and so I'd send it back and ask them to clarify. This man says that this happened in 1963, and yet his date of birth is 1959. What is this about? This doesn't quite fit. We had many people who were quite elderly and were tortured their whole lives by what had happened to them, and simply couldn't talk to a complete stranger on an initial phone call about what happened and how it impacted them.
Mr. Kosnoff, my question related in particular to your reference to the fact that you didn't bring some claims because other entities might be liable. With
Sure.
regard to those cases, what other entities or what kinds of entities were liable in a way that you didn't want to bring the claim against the Boy Scouts of America?
Well, for example,
Objection. I just admonish the witness not to reveal attorney-client privileged information. Thank you.
somebody discloses that they were assaulted by their physical education teacher at a public school, this is a hypothetical, in New York City. No connection to the Boy Scouts of America. He may have a viable case, but not against the Boy Scouts of America in the bankruptcy.
That's fine, thank you.
That's one example.
So at the time of the bankruptcy case, approximately how many clients did you and Mr. Eisenberg and Mr. Van Arsdale represent in connection with the Boy Scouts?
Andrew would be better at this, but I would say 5,000.
Okay. Thank you. Madam Court Reporter, could you upload Exhibit 1?
I believe there is a tech on that will be doing that.
Mr. Patterson,
Yes.
Dan Hogan here. I just wanted to make sure that you weren't going to be producing anything that we've objected to as being privileged. But it
I'm
appears,
sorry, it froze again. I wanted to make sure that you weren't. Mr. Hogan, what did you say?
Daniel Hogan, representing Eisenberg Rothweiler, I was asking Mr. Patterson if he was intending on producing and displaying documentation that I had previously objected to as privileged. From this perspective, this document, he is not. This is a court filing. And so I'll reserve my comment until if and when he decides to do that.
Mr. Kosnoff, do you recognize the cover sheet of this document?
I do. It's my verified statement. Excuse me, it's the verified statement of abused in scouting pursuant to Rule of Bankruptcy Procedure 2019, which was something that Judge Silverstein ordered AIS, or the attorneys comprising AIS, to file.
Could the tech advance this to Exhibit B, please? Thank you. Do you recognize this document, Mr. Kosnoff?
Yes, I do.
What is it?
It's the standard professional employment agreement that we used, 3 law firms, with our clients.
Is this the form of agreement that was used for clients that you retained prior to the bankruptcy?
Yes,
It was the same form?
it never changed. Well, it was superseded later when we elected to bring lawsuits against the BSA, local councils, and so forth in the states of Arizona, Hawaii, and New York. But it was essentially this form, but it was expanded.
I note that this form refers to a February 18th, 2020 bankruptcy filing. I take it that language was not in the original form that you used prior to the bankruptcy case when the case had not yet filed.
Sorry, you froze. Mr. Patterson, you froze. I take it that language was not.
Included in the form that you used prior to the bankruptcy case.
That's correct. We did not know and could not know when they were going to file.
But otherwise, was the form approximately of this length and had this structure?
Yes.
Other than what you have referred to, which is the pre-petition form, and then later a form that was used for clients in Arizona, Hawaii, and New York, is there any other retention agreement between you and the clients that you represent in connection with the Boy Scouts case?
Between our 3 law firms? No.
Well, just start with you.
Okay. Question again?
Other than this agreement and the agreement similar to it that existed prior to the bankruptcy, and the agreements that you referred to with regard to clients from Arizona, Hawaii, and New York, is there any other form of agreement that you used to retain, for clients to retain you in connection with the Boy Scouts bankruptcy case?
No, sir.
Are you aware of any other form besides the ones I just referred to, whereby your co-counsel, who are listed at the top, represented clients in connection with the Boy Scouts case?
Could you state that again?
Let's back up. At the top of this form, it says AIS, and then it says abused in scouting. And below that, there are 3 names. As I read it, it's Eisenberg, Rothweiler, Philadelphia, Pennsylvania, Kosnoff Law, I can't read it, what is that, San Juan, Puerto Rico, and AVA Law Group, San Diego, California.
Okay.
Are those three names that I just read the lawyers who served to represent the clients that you signed up?
Yes,
And each of you agreed to serve as a lawyer for the clients who were signed up?
yes.
Thank you. Mr. Kosnoff, did you borrow any money for purposes of meeting the expenses contemplated by the signing up of clients in connection with Boy Scouts?
No, sir.
Are you aware of whether either Eisenberg Rothweiler or AVA Law Group borrowed money in connection with that endeavor?
Objection to form.
Well, with respect to AVA Law Group, I'm not acquainted with their financial structure. You'd have to ask Mr. Van Arsdale. With respect to Eisenberg Rothweiler, I believe they had a line of credit with a bank to finance operations and costs associated with their contingency fee practice.
Are you aware of, let me back up. Did you personally, on behalf of yourself or Kosnoff Law Group, ever pledge the amounts that you would recover from the claims in Boy Scouts to a bank or other lender?
Objection
No.
to form.
You
I'm
may
sorry,
answer.
who was that? Mr. Hogan?
No, it's Cameron Moxley. Thank you.
You may answer, Mr. Kosnoff.
No, I did not.
Are you aware of whether either AVA Law Group or Eisenberg Rothweiler pledged their right to receive fee income from the Boy Scout claims to a bank or other lender?
Objection to form.
I reasonably
I'll second that objection.
I'm reasonably certain that AVA did not. I have reason to believe that Eisenberg Rothweiler did.
I just want to make sure I heard you. The last word with respect to Eisenberg was DID, did?
That they did borrow money over and above the line of credit that they owed to their bank.
And what is the source of your knowledge regarding that?
Objection.
I was presented with loan documents by an entity on Wall Street that described the amount, the terms, and so forth. When I finally understood what was happening, I refused to sign them, and that was at about the time I withdrew as a member of the coalition.
I'm sorry, you froze again, and that was out about the time.
That I quit being a member of the coalition.
Madam Court Reporter, this is Erwin Zalkin. I think you're having trouble with your internet or your reception, because I think for, at least in my case, I haven't seen any disruption with Mr. Kosnoff's video or testimony. I think maybe we should take a break and you ought to check your service or your connection.
I'm sorry, you believe that my connection?
No, not you. I'm talking to the court reporter, because I've been seeing you fine. There hasn't been any interruption from my view of you and your presentation. It seems to be the court reporter who may be having trouble, and I think that maybe you should check that.
I'm in the same position. Would it be helpful, court reporter, to take a minute break and allow you to check your connection?
I could sign out and come back in again. I don't know if that would help.
Let's find out. Let's take 2 minutes and you can do that.
Okay.
Okay, so we're going off the record at 10:28. And we're back on the record at 10:32.
Mr. Kosnoff, referring to your prior answer, you indicated that you refused to sign the loan documents, quote, when I finally understood what was happening, close quote. What do you mean by that?
Objection to form.
Well, wait for it, Mr. Schiavone, here it comes. I was bamboozled. Would you like me to elaborate?
Who were you bamboozled by, Mr. Kosnoff? What was the bamboozlement?
Objection to form.
The bamboozlement was Ann Andrews and to Brown Rudnick.
Do you believe, did you come to conclude that the goals that you had for the bankruptcy case were different from the goals that others had?
Yes.
Objection to form.
Yes, I believe I was misled.
What were you misled with respect to?
This
You
will,
had calls for speculation.
no,
Mr. Kosnoff, what do you believe you were misled with respect to?
I believed that when I quit associating with the official committee, and the reasons why I quit were the reasons that we were going to band together and to hire private counsel to represent us in pursuit of an adversary proceeding in the bankruptcy that the TCC would not do.
Let me note my objection. This is Cameron Moxley of Brown Rudnick on behalf of the coalition. Let me note my objection to the question. I'll move to strike the answer as non-responsive and irrelevant.
What was the lawsuit that you believed the TCC was not going to pursue that you wanted pursued?
Well, it was not just me. It was the members of the coalition, two other law firms, Zuckerman Spader, and we believed that the issue of the separation of the local councils from BSA National was a fiction, and that the councils were controlled to such an extent that they were the alter ego of the Boy Scouts of America, and that therefore the assets of the local councils should be consolidated, substantively consolidated into the debtor's estate. And my departure and frustration was about that. And Andrews reached out to me and expressed her agreement and support and suggested that we needed some top litigators to handle this. So we began, and we talked to one law firm before we talked to Brown Rudnick, and there were discussions before the retention, which I can discuss, but discussions after the retention, I think I have to honor those discussions. Once I was a member of, I was never a member of the coalition, but I had clients who were represented by Brown Rudnick. But the discussion changed fairly quickly. And what changed was it was no longer about what I wanted to see happen, which is to bring in a litigator to pursue substantive consolidation of the local councils into the debtor's estate, but something completely different. And initially it was Ann and Schulman and Slater, and I'd gotten to know them a little bit because they had had clients on the TCC. And within a week or two, there's suddenly people that I've never heard of before. Law firms that, I mean, I know who represents abuse survivors around the country. You know, I've worked with many of them. And none of these people were in that world. And so it was in a phone call, I believe, with Ann Andrews and Adam Slater when I was expressing concern that I didn't know what had happened and who these other law firms that were being brought in. And they said, Joe Rice wants to join the coalition. And I said, who is Joe Rice? You don't know who Joe Rice is? No, I didn't know who Joe Rice was. But I Googled him and found out pretty quickly who he was. And I was pretty sure he wasn't somebody I wanted to be associated with. And it was all about getting in all these other law firms into the coalition. And then I discovered what had happened is I had wandered into an entirely different legal ecosystem. What I knew about the mass tort world, I read in a John Grisham book 15 years ago, and it wasn't particularly flattering. So while I had represented multiple clients in cases, I didn't understand this at all, and I wanted no part of it. So yeah, I felt cheated.
Did you understand?
Pardon me. Cameron Moxley, on behalf of the coalition, object to the question and answer for the same reasons as before. Move to strike the answer as non-responsive and irrelevant, the same reasons as before. Thank you.
Did you understand the goals of the lawyers that you just referred to in the case to be different from your goals?
Yeah.
Same
Yeah.
objection. Same objection, same motion.
How were they different?
Same objection.
Objection calls for speculation.
Well, it doesn't call for speculation, but it does call perhaps for me to reveal communications that at the time I agreed to maintain confidentiality.
What were your goals?
Down the form of privilege then, if that's the case, and ask that you not divulge those privileges.
Well, again, I don't know, and perhaps this is an area that court will have to resolve. But yes, there were communications, and from those communications, it was quite clear to me that they did not share my goals, and I did not share their goals.
Okay.
The same motion to strike.
And just for the record, we do not accept the assertion of privilege, but understand that the witness is not answering the question at this juncture based on the assertion, and so we'll move on. Going back just a second as a housekeeping matter to what I pulled up as tab 1, I'd like to have that admitted as exhibit 1 to this deposition. I take it there's no objection to that.
Well, counsel, there's no admission into evidence at a deposition.
I understand.
Well, do you? I mean, I'm just being clear. There's no admission into evidence, so there's no basis for anybody to object at this point. You've marked something as an exhibit that was shown to the witness at the deposition.
There have been assertions that one or more of the documents that we might be producing or making available is subject to a privilege. So I was inviting that objection if it was applicable here.
That objection is not applicable to the 2019 statement. That is part of the public record.
Thank you. Mr. Kosnoff, was there ever an understanding between the three lawyers who represented the clients, you, the Eisenberg firm, and AVA Law, with regard to communicating with clients?
Objection.
On the grounds of privilege.
I'm asking whether there was an agreement between the lawyers with regard to communicating with the clients.
I understand that, but to the extent that he divulges privileged communications as a result of answering that question, I need to assert the privilege.
Okay, so other than in conversations themselves with clients, was there an agreement that you made with Mr. Van Arsdale or with Mr. Rothweiler or other lawyers at his firm with regard to the protocol for each of you contacting clients?
Excuse me, this is David Wilkes. Excuse me, Mr. Kosnoff. Let me just make 2 points. One, as we all know, privilege belongs to the client, not to attorneys, and that applies to all the privileges that anyone has discussed today. Second of all, it applies to communications with clients, between clients and attorneys. So with that, Mr. Kosnoff, you can answer the question.
My answer is that was our course of conduct. So I guess there was an implicit agreement that since all three of our law firms jointly represented all of our clients, that each of us had a right to communicate with our shared clients.
Note again my objection and the same motion to strike for the same reasons. Thank you.
Mr. Kosnoff, when you referred to the departure or the difference in goals that you had from those of the coalition, and you declined to answer with regard to what the coalition's goals were, can I ask you what your goals were?
My goals were to maximize the financial recovery for the survivors and to deliver them a measure of justice that they deserved.
After you left the TCC and then after you left the coalition, can I ask you when you date the time that you left the coalition?
Roughly end of September, early October, ballpark.
And after that point in time, did you continue to communicate with Mr. Rothweiler or lawyers at his firm and Mr. Van Arsdale?
Yes, as had been our practice, we had weekly phone calls and sometimes, daily phone calls as the claims bar date approached.
Were there disagreements among the three of you during that period of time?
Yes.
And when did disagreements arise?
At or about the time that I had resigned from the coalition and urged Eisenberg Rothweiler to resign as well.
And they declined to do that?
That's correct.
Did Mr. Rothweiler or anyone at his firm tell you why they declined to resign from the coalition?
Object to form.
Well, my communications concerning Mr. Rothweiler and my concerns about Mr. Rothweiler go way back in time. And those were conversations that I had with Mr. Eisenberg about the conduct and credibility of Mr. Rothweiler. So while I was able to
perform as there's not a question pending about Mr. Rothweiler, your opinions about it.
What were the concerns you had with regard to Mr. Rothweiler?
Objection to form.
Same objection.
that he was not straight. He was not honest in his communications with me. I was concerned about his personality and how he had thrust himself into this case after I had had numerous discussions with Mr. Eisenberg that I didn't want Ken Rothweiler anywhere near this case, and was given assurances by Mr. Eisenberg that he could keep the Rothweiler under control. Those were my concerns.
I move to strike the answer as non-responsive and irrelevant.
Yes, I will join in that.
As will I.
Are there specific instances that you can recall where you believe that Mr. Rothweiler misled you?
Object to form.
Mr. Rothweiler had limited experience in child sexual abuse litigation, and particularly bankruptcy litigation involving child sexual abuse. He was pushed forward by Ann Andrews to be the lead negotiator for the coalition. This was concerning to me on a number of levels because of my past difficulties with Mr. Rothweiler. And I believe it was in early December, I spoke to Mr. Eisenberg either by telephone or email, and I urged him to quit the coalition. I told him that Ken does not speak for AIS or our three law firms, and I don't agree with the goals of the coalition, and that if you don't leave, it will drive a wedge between us. And that has proved to be true.
Same motion to strike for the same reasons.
Seconded.
Mr. Eisenberg said, I can't do that. And I said, why? And he said,
Pardon me, I don't think there's a question pending.
When was the last time, Mr. Kosnoff, that you spoke to Mr. Rothweiler?
I believe it was December. He may have sent me an email demanding that I pay him $400,000 in January, which I disregarded.
Motion to strike, clearly non-responsive.
And during your last conversation with Mr. Rothweiler, was there a disagreement that was articulated between the two of you?
Mr. Eisenberg or Mr. Rothweiler?
Mr. Rothweiler.
After I left the coalition, there was a problem because the coalition had sought unsuccessfully initially to be admitted, well, to get its 2019 approved to the satisfaction of the court, or to be admitted as a mediation party. Notwithstanding that I was not a member of the coalition, I expected to be able to participate as a mediation party. And that was, as I understand it, objected to by Mr. Schiavone. Mr. Schiavone and Brown Rudnick, as I have been told, negotiated an agreement that if Kosnoff was excluded, that he would drop his objection to the admission of the coalition as a mediation party.
What was the source of your understanding with regard to that agreement?
Pardon me, counsel, move to strike for the same grounds, relevance and non-responsive.
What was the source of your knowledge of that agreement?
It originated with Sonny Bevel and was related to me by, I believe, Mark Byrne.
Same motion.
Thank you. Could the tech upload tab 38, please? Could you scroll down so that to the next page? Mr. Kosnoff, do you recognize this email?
Yes.
You're listed as a recipient of it. It's dated September 7, 2020 from a Joseph Steinfeld. Do you know who Joseph Steinfeld is?
I've spoken with him. I've never met him in person, no.
To your understanding, who is he?
He is somehow associated with Andrews and Thornton, and I think they co-jointly represent claimants in this bankruptcy. And he was, I guess you would call the sort of money guy of the operation that knew and was familiar with these loan agreements and their structure and so forth. And so we were the cats and he was trying to hurt us.
Could whoever has control over the document scroll to the page entitled Loan and Security Agreement? Is this the loan and security agreement, Mr. Kosnoff, that you referred to earlier in your testimony that you were asked to sign?
Yes. Let me correct that. That's dated 9/4/2020. I can't be sure that this is the final, it says draft. I may have seen earlier versions or later versions, but I have seen this one.
And is it your understanding that Eisenberg Rothweiler or Mr. Rothweiler signed this document or a document like this to borrow money in connection with the Boy Scouts claims?
Let me just,
Objection calls
let me
for
just,
speculation.
yeah, let me just object to this question, the use of this document, and move to strike all questions and answers related to this document as irrelevant. Thank you.
You may answer, Mr. Kosnoff.
I can't say that I've seen this document with their signature on it, unless this one contains their signature. I know that there was a holdup because their line of credit was secured with all of their cases, their contingency fee cases, including their interest in the Boy Scout cases. And so I think it took them some time to iron that out with that lender. And by that time, I think I was out of the picture. So I guess the answer is, I can't say for sure.
In addition to my prior objection and motion, I move to strike that specific answer as non-responsive.
Could you upload tab 2, please? Oh, I'd like, pardon me, before we do that, I'd like to designate tab 38 as exhibit 2. So let's go to tab 2, please. Is this document familiar to you?
Yes.
I'd like to direct your attention, and what is it? What is it?
This was the 2019 verified statement that I specifically was ordered by Judge Silverstein to file.
Okay. And you participated in the drafting of this document?
Yes, I did.
And you approved its filing with the court?
I did.
I'd like to direct your attention to page 4 of the document, please. Paragraph 9.
Can you make it bigger? Okay, that's better. Thank you. Yes, I know this paragraph well.
Okay. What did you mean when you said that your participation in the co-counsel arrangement was predicated on the three firms would never accept the use of a master ballot?
Check the form.
Well, the term master ballot is one that I wasn't particularly familiar with, and people seem to use that in a wide variety of circumstances. But to me, master ballot was where the lawyers voted for their clients. And I rejected that, and I said each client will vote his or her own ballot, period. And there was no objection to that, and there was agreement with it.
I'd like to introduce tab 2 as exhibit 3, please. Have either Mr. Van Arsdale or Mr. Rothweiler or another lawyer at Eisenberg Rothweiler objected to you contacting the clients of Abused in Scouting?
Never.
Check the form.
And it's your understanding that the protocol among the three of you is that you are free to contact the clients of Abused in Scouting?
Check the form.
Yes, and vice versa.
By vice versa, you mean that they are free to contact you?
Clients can contact Andrew, me, Stuart, Josh. We represent them. We're their lawyers. They have a question, they have a right to call us, and we have a right to call them.
Have you ever had a disagreement with either the Eisenberg Rothweiler lawyers or Van Arsdale with regard to a specific communication made to clients?
Object to form.
Yes, multiple.
Can you describe some of those?
Same objection.
Well, let's start with Ken Rothweiler going on Lester Holt, NBC, and other news outlets, the NewsHour, trumpeting this colossal achievement, which we know as the RSA, making representations about it, knowing that that broadcast would be viewed by our clients and many other people. So that's one. Of course, I can't know what Ken Rothweiler is saying to clients on emails that I'm not copied on, or in phone calls that he's had with them. But I have watched his town halls. I listened with keen interest when he spoke during the plan disclosure statement hearing. And on each one of those occasions, I strongly disagreed with representations that he was making. And then lastly, maybe not lastly, if I thought about it, I could probably think of some more, but was this e-ballot that was sprung on me and our clients by Eisenberg Rothweiler and all the members of the coalition.
Okay, let me take those piece by piece if I can.
Let me just move to strike the answer as non-responsive and irrelevant again. Go ahead, counsel. Thank you.
First, in your answer, Mr. Kosnoff, you referred to the plan as a colossal achievement. And sometimes it's a little difficult to pick up intonation in matters. Were you being sarcastic or ironic when you used those words?
Yes, completely.
Thank you.
The RSA was, in my opinion, a disaster and grossly misleading.
There's no question, Pen.
Did you communicate your disagreements with the communications to Mr. Rothweiler or Mr. Van Arsdale?
I hadn't spoken to the Eisenberg firm for 6 months as of the time that RSA was announced, which I believe was in late June. And I did speak with Mr. Van Arsdale about it. I told him it was just a terrible deal for the clients, that I was not surprised that this was announced by Ken and the coalition, but that I was surprised and perplexed at why the TCC also signed the RSA. So we talked about that and he agreed with me. It was an insufficient amount of money and it was a completely implausible scenario for restructuring the Boy Scouts of America and fairly compensating our clients.
Move to strike.
Let's introduce, if we can, tab 3, please. Can you scroll through it, please, so Mr. Kosnoff can see the whole document?
I'm sorry, this is tab 3?
Yes.
Okay.
Mr. Kosnoff, I'm going to refer to this document as the October 18th letter. It doesn't have a date at the very top, but there's a header on the succeeding pages that says October 18th. Are you familiar with this letter?
Yes,
Does this letter fairly state your objections to the current plan of reorganization for the Boy Scouts?
it does.
Did you participate in writing this letter?
I drafted it, and it was subsequently edited by John Lucas of Pacholsky Stang, who corrected some things in it, and by my attorney, who took out some of the Tabasco sauce, if you will. I'm passionate, and sometimes it's hard to keep it out of my communication. So I depend on people to edit me.
Do you know whether this letter was made available to the clients of Abused in Scouting?
Yes, it was. It was sent out in an email communication coming from Andrew Van Arsdale's office to all of Abused in Scouting's joint clients. I think about 2 days after this, around the 20th, and it was sent out with, if I remember correctly, it had both Eisenberg Rothweiler's letter linked, and this letter was linked in that email. But I seem to remember that there was an earlier email that was sent out by Andrew that only contained the Eisenberg letter.
Did you request Mr. Van Arsdale send this letter to the clients of Abused in Scouting?
I did.
And he agreed to do so?
Yes.
After this letter was sent out to the clients of Abused in Scouting, did either Mr. Van Arsdale or Mr. Rothweiler object to its contents or the fact that it had been sent to the clients?
None.
Is this the same letter that was subsequently sent by the Tort Claimants Committee also to your clients and others in early November of this year?
Object to form.
I believe so. Well, yes.
Why did you ask, or pardon me, let's strike that. What were the circumstances surrounding this letter being sent in early November?
Object to form.
Okay, by way of background, I had been estranged from Eisenberg Rothweiler for 6 months. Andrew Van Arsdale was somebody that I thought I knew and trusted and communicated with him openly. And he revealed to me in June that he was going to sign the RSA. And I rebuked him severely for doing that. And we've communicated only as necessary. I know he's continued to maintain communications with Eisenberg Rothweiler, but neither of those firms, I believe, have honored their fiduciary obligations to me to keep me informed as to what they were doing with respect to our joint clients. So I wasn't sure that Andrew would send out this letter. And the reason was because I had earlier asked him for our client email lists because I wanted the TCC to be able to send out their notices of their Tuesday night town halls, which I had been watching, found useful and believed would be useful for our clients. He said, I can't do that. And I responded, then give them to me and I will give them, well, I don't think I actually told him, I said, give them to me. And reluctantly, he did in spreadsheet form. And I, in turn, gave them to the TCC.
Move to strike as non-responsive.
So in November of this year, you had an email communication with Mr. Lucas with regard to sending this letter a second time to the clients of Abused in Scouting. Is that correct?
We had a communication, but I don't recall that I was asking him to send out this letter again. What I had wanted him to do was send out an email, which was in response to what had just happened, which was the e-ballot system that the coalition was using and distributing to tens of thousands of clients, including mine. I had not been given any notice of it. I had not been given a chance to preview it. It was sprung on me. So I contacted John Lucas. I told him that clients are calling, that they are angry, they're upset, and they don't understand this e-ballot. They're having problems with it. And we have to do something. There's an emergency here. Can your firm do something? And I said an email should say something like this. And I just drafted it and sent it to him. And he looked at it. He says, "Do you want us to send this out?" And I thought to myself, yeah, I have no technical ability to send out 15,000 emails. I mean, I knew that I was going to have to hire a service to do that, but I hadn't set up an account so that I could utilize one of these services to broadcast large numbers of emails. And it was, I believed, an emergency situation.
So is it correct to say that if,
Pardon me, same motion.
is it correct to say, Mr. Kosnoff, that if the TCC had not sent out that email on your behalf, that you could have made arrangements to send it out yourself?
Object to form.
Yes, I could have. There are companies like Constant Comment and so forth, but you've got to set up an account. That takes time. You have to upload, and there wasn't time.
Mr. Kosnoff, I can't remember if I've marked this as an exhibit, but I'd like to mark this as the next in number exhibit to the deposition. Did you ever have discussions with Mr. Van Arsdale or Mr. Rothweiler with regard to how Abused in Scouting would solicit the votes of its clients on a plan of reorganization?
Objection.
Yes, as stated in my 2019, I expected that the official court-approved printed ballots would be mailed or emailed to our clients, and they would vote their own ballot, sign it, return it to us, or return it directly to Omni.
And did you have that specific discussion with either Mr. Van Arsdale or Mr. Rothweiler?
Objection. And let me just note for the record and advise the witness, if the answer involves discussion that you may have had with those individuals while you were a member of the coalition, I would request and admonish you not to reveal privileged information.
Excuse me, this is David Wilkes. A couple of points. One, no lawyers are members of the coalition unless they are in fact abuse victims or survivors. That's number one. Number two, as I mentioned, privileges belong to clients. They are theirs to assert or to waive. Also, I'll take this opportunity, Mr. Patterson. We've been going for a couple hours. We had a brief little break for the technical issue, but I'm not asking for a break right this minute, but at your next available breaking point, I think we could all benefit from a short break.
Oh, let's stop here. Let's take 15 minutes here.
Pardon me, before we break, let me just respond to Mr. Wilkes briefly. Fair enough with respect to the members' comment, Mr. Wilkes. But on the privilege issue, I do want to know if counsel to the claimants were discussing amongst themselves during the July 2020 to September 2020 period of what they were going to advise their clients, what approach they were going to take strategically, those are privileged. And the coalition has not waived that privilege.
Okay.
I would add also that to the extent that those conversations occurred after that point, there's a common interest privilege that Eisenberg Rothweiler asserts, such that those discussions should not be divulged.
Okay.
Excuse me, this is Joseph Gray. I'm from Cross and Simon. We've been working with the ABA Law Group. Just want to second Mr. Hogan's last comment. AVA would also have a common interest privilege that's not something the clients can necessarily waive.
Well, that's plainly incorrect. The common interest privilege is just an extension of the attorney-client privilege. But I'm not going to dicker with you over on this record.
Well, my question was, did you have a specific discussion with either Mr. Van Arsdale or Mr. Rothweiler with regarding to the form of ballot that would be delivered?
And the same objection and the same comments with respect to privilege.
Same here.
Yes, that the official ballot would be the ballot that the clients would receive and that it would be sent out on ABA.
And was it your understanding that they agreed with that position?
Same objection, same
objections.
I was never informed that they had a different strategy.
Okay, let's take a break. 15 minutes?
Sounds good.
Okay, and we're going off the video record at 11:15. And we're back on the video record at 11:30.
Thank you. Just before we start, Mr. Kosnoff, a note for Mr. Hogan and Mr. Moxley, who I think interposed common interest agreement objections. If they could forward to me copies of all applicable common interest agreements, I would be grateful to see those.
Let me just note for the record that I did not assert a common interest. I asserted attorney-client and attorney work product privileges. Mr. Hogan may wish to address the common interest.
And this is Joe Gray. I think I raised that too. I also wanted to add work product.
And just for the record, so that it's entirely clear, I asserted all three: attorney-client, work product, and common interest.
Correct. The common interest is generally evidenced by an agreement. So if you could send me a copy of any applicable agreement, I'd be grateful.
Understood. I understand the ask.
Mr. Kosnoff, without regard to conversations or exchanges that you had just with Mr. Rothweiler or Mr. Van Arsdale that were private among the three of you, excluding those contacts, were there statements made by Mr. Rothweiler publicly that you felt were misleading with regard to the plan of reorganization for the Boy Scouts?
Objective form.
Yes.
Same objection.
And can you recall, as you sit here today, what some of those statements were that you believed were misleading?
Same objection.
Same.
Well, starting as early as his precipitous announcement of the RSA on national television, all the way through his multiple town halls and comments to the media, he has said things like, this is the biggest settlement in the history of child sexual abuse litigation. And without mentioning that while it's a very large number, there's 82 to 85,000 claims in this case. And so it was historic, but not in the way he was representing it. It was historically low. That's number one. Number two is he would continue to say that this is just the beginning. There's going to be billions and billions more. I knew from what the RSA contained, and then eventually what the, was it the fifth or sixth amended plan, whichever one is before the court now, that there was never going to be billions and billions more. So that was grossly misleading. He would stand in front of a map of the United States and say, look at all these states. There's only, look at it, you got a few of them, California, New York, New Jersey. The rest of them, you know, just shut down on statute of limitations. That was misleading in the extreme and a mischaracterization of statute of limitations generally, but also statute of limitations within the context of litigation, which is statute of limitations is not a bar, it's a defense that has to be raised by the defense. And there are defenses to the defense of statute of limitations. So he was misleading with respect to statute of limitations and was leading the lay viewer to believe that even though he was going to get billions and billions more, you couldn't have expectations too high. He talked about how hard the coalition had negotiated, squeezing nickels, and he would post on his Facebook pictures of him from some skyscraper in New York where he was in mediation. He posted Facebooks of he and his wife on a super yacht in Los Angeles when they were supposed to be in a mediation, you know, bragging about partying with his rich buddies. The way he was presenting himself was misleading. That he really had an understanding of the intricacies and complexities of this case. For example, I wrote and maintain that the settlement with the Hartford was a disaster because it capped what could really be successfully negotiated with the remaining insurers. Ken either didn't understand that or he didn't care. The next thing is I listened carefully to I was on, I think, every court hearing since the inception of this case. And I was impressed by the quality of lawyering, particularly from the insurance lawyers. And in addition, Mr. Schiavone was entertaining, but they made points that were dead on. And what they said to the court was, this plan is legally unconfirmable. And they explained to the court why. And they were right. This plan is legally unconfirmable, in my opinion. Second, the notion that the insurance company's contract rights could be torn up, particularly as applied to non-debtors in this case, for which there was no legal support. These were all things that were, I think, misleading by omission by Mr. Rothweiler and the coalition.
Thank you.
Motion to strike on relevance and non-responsive.
I'll second that. Thank you.
Can I object to being called entertaining? I mean, I don't know if that really abides by the Delaware Code of Civility.
Okay, I'm no bamboozling here. So, no,
there's no question pending, Mr. Kosnoff. There's no question.
Mr. Kosnoff, there's no question.
There's no question, Mr. Kosnoff.
Mr. Schiavone, you don't want to hear me?
So I'd like to ask you whether you have received any communications from clients of abused in scouting saying that they believe that they have been misled by Mr. Rothweiler or his communications? And it's a yes, no answer.
Check the form.
I think the answer got buried, Mr.
You can
Kosnoff.
answer yes or no,
Yes.
Mr. Kosnoff.
Yes.
And I take it, Mr. Hogan, if I were to ask him to recount the substance of those conversations, you would object?
I will, yes, on all the grounds I mentioned before.
And Mr. Patterson, if you do object, I'll admonish the witness to observe his client's privilege to the extent that that privilege has not been waived expressly by a client or clients.
Okay, where are we now?
Mr. Kosnoff, I have a question for you. Let's upload tab 7, please. Mr. Kosnoff, do you maintain a Twitter account?
I do.
This has listed on it, says on it, Twitter for iPhone. Is this a tweet that you tweeted?
No, this was actually somebody, I think, who responded to me on Twitter.
Okay. It seems to indicate that it's caught from Kosnoff at Sex Abuse Attorneys. Is that your Twitter handle?
It is, but if you'll notice, it says thread.
Mm-hmm.
So this, if you know how Twitter works, you can post a tweet and then people can reply to it, respond to it, and it becomes a discussion. So I think this was part of a thread responding to something I tweeted or maybe one of my other followers tweeted.
Okay, let's go to tab 8, please. Do you recognize the text at the top of tab 8, Mr. Kosnoff?
I do.
Is this a tweet that you sent out?
Yes.
Can you tell me the circumstances under which you sent this out?
Check the form.
Well, I had just received calls and emails from people upset asking me what this e-ballot thing was. And I didn't know what it was. And I asked them to send it to me. And they did. And I reacted by texting Andrew.
And what is the e-ballot?
The e-ballot is what the coalition law firms are using. And frankly, I don't know what it is. It's not my understanding of what a master ballot is. And most clients, most people in the world know what a ballot looks like. And this looked like no ballot they'd ever seen before. So I didn't know what they were doing, but I immediately went to Andrew and protested that I was not provided with this. I didn't understand what it was, that clients were not understanding what it was, that there were problems with it. And I demanded to know why I wasn't informed that this e-ballot thing was going to be used. But actually before that, he did reference in a text that he didn't know anything about it, but they're using some kind of email app. And Ken had mentioned something that they were going to use an easy to use voting app. And that was maybe a week and a half before. And I texted Andrew, what is Ken talking about? This vote by app. And he said, I don't know. I said, I want to see it. He said, I'll forward it to you when I receive it. And then a week and a half, several days passed. And I looked up e-ballot, this company, and saw what it was and became, alarmed. I didn't know what it was. The way it could be manipulated. But most importantly, it was not what the court had approved. I expected the clients to receive the official printed court-approved ballot, not this thing, whatever it was.
Thank you. And I apologize.
Pardon me, counsel. To strike. Thank you.
Go ahead.
I just made a motion to strike.
And I apologize because I can't recall who it is who is representing Mr. Van Arsdale or AVA on this deposition. Who is it?
It's Joseph Gray from Cross and Simon.
Thank you, Mr. Gray. Mr. Gray, one of the documents that was produced is a text exchange between Mr. Van Arsdale and Mr. Kosnoff with regard to the e-ballot. Do you object to my making it available in this deposition?
I have not seen it. So I'll have to take that under advisement. Till I see it, yes, I would object.
On what basis do you object?
Well, I haven't seen it, but I think the work product doctrine could apply.
To that logistical point, Mr. Patterson, you referenced tab numbers when you refer to certain documents. I certainly haven't received the documents that are referenced by tab numbers. If those could be available to counsel participating in this deposition, that would be
okay.
Could
the court reporter?
Excuse me, Mr. Pettis, just let me make a point. Mr. Gray was provided with that document along with everyone else who was served.
Okay.
As everyone knows, I did not have an opportunity to look at these things. I was out of town.
Well, it was this morning.
We went through that last week.
Yeah, it was served on you this morning, Mr. Gray.
So
this morning?
Court reporter, could you call up exhibit number, tab number 41, please? Could you scroll through it so that the witness can see the entirety of it? Hey, Mr. Kosnoff, do you recognize this document?
I do.
I just want to object. This is Joseph Gray. I do think this is work product communications between attorneys. There's also conversations with clients that are referenced in this. So it's attorney-client privilege as well.
Are you making an objection on attorney-client privilege?
Yes, and I would ask the witness to please not respond to any questions about this. And I moved to strike this exhibit.
Okay, take it down, please, court reporter. Your objection is noted. We don't agree with it, but we note it.
Thank you.
Mr. Kosnoff, did you receive any communications from clients with regard to the e-ballot?
form.
I'm sorry, did you say the e-ballot?
Yes.
Yes.
Without characterizing any particular conversation at this point, what was the substance of those communications?
Objection as the form.
Same objection.
Okay. Court reporter, could you call up tab 9, please?
Excuse me just one moment.
I just want to clarify, are we marking tab 7 and 8? as an exhibit.
Not 7. Yes, 8.
All right, thank you.
And now we're on 9. Mr. Kosnoff, do you recognize exhibit, the document that's currently on the screen?
Yes, I do.
And is this a tweet that you sent out on or about the date indicated on the document?
I did.
Can you tell me the circumstances under which you sent this or issued this tweet?
Checked form.
Sure. Within minutes of the coalition's e-ballot going out, my phone was literally ringing off the hook, my cell phone. I have received probably in excess of 1,000 voicemails, emails, texts, comments on Twitter expressing outrage and upset at how Rothweiler had used this vote by app thing called an e-ballot. There was mass confusion. People were upset to be receiving this in their email box. It was triggering, re-traumatizing. And then I heard complaints, many complaints, that the e-ballot was dysfunctional. People couldn't use it on their phone, which was their only communications device. They didn't have a computer. I was hearing objections that it wouldn't let them complete the ballot. It wouldn't accept it. It wouldn't allow them to enter the client information. It would freeze. One man related that he couldn't get it to accept the reject, and he kept trying and trying. And finally, out of frustration, he changed the reject to accept, and then it accepted it. So I was hearing those stories. A lot of these men are, technologically capable, work in the industry. And so I received several responses that said, what on earth are you sending out a ballot that contains the username and password within the email itself? This is email security 101. So they raised those kinds of security concerns in addition to other concerns. And then as the days followed, as if the original email ballot wasn't bad enough, they were now getting 4 and 5 a day, spam attacks, essentially, and expressing insult that they had just lost, they had lost their confidence in the integrity of this process. Many commented that, when you go into a polling place and you vote, they don't get to just, the supporters of one side or the other stand over you and scream into your ear, vote yes, vote yes, vote yes. They pointed out that on each page of the e-ballot, Ken Rothweiler had vote yes, vote yes. And this is going on up to the present moment for the last 2.5 weeks. They're continuing to, they asked me, can't you make it stop? And I said, we're trying. And I apologize. And they said, well, how am I going to be able to cast my vote? I said this, and so much of my time was spent responding by giving them the link to the Omni ballot, where they could just send an email and request a physical ballot, and they get it. And gratefully, Omni was pretty good at getting those out. This was particularly problematic because many of these men had been watching the town halls, and the TCC was going through the official ballot and explaining the different sections. and what they meant and how to vote. But that wasn't what they were receiving. They were receiving something that was completely alien to them. There were so many men I couldn't get back to. I had to delete their voicemails because I couldn't retain them. I had to delete them so that other people could at least call. So I'd take a screenshot of the ones I deleted before I had to delete them, but they just came coming in. And, you know, I guess this started on Friday, and every 5 seconds my phone was ringing, and I somehow thought I was going to be able to return these calls. And so I spent maybe 12, 14 hours between 3 o'clock in the morning on Saturday and 10 o'clock at night on Saturday, calling people back and trying to answer their questions, which I woke up Sunday morning and I said, this isn't going to work. So I crafted my Sunday morning email and started sending it out in reply to these men and asking them, you know, I explained what the circumstance was and asked them if they had any questions to please read my October 18th letter. And I added further information in that Sunday morning email, really just in an effort to try and get my arms around what was happening, which was that the coalition was destroying the integrity of the vote.
I'm sorry. Please continue, Mr. Kosnoff.
Well, that's my opinion.
Sorry, I couldn't hear you, Mr. Moxley.
Sure. I think the evidence is so overwhelming that this was an ill-conceived and improper effort to gain some kind of advantage over lawyers like myself who are opposed to this plan. I'll stop there.
Pardon me, Mr. Kosnoff, I didn't mean to interrupt you before. Let me note my objection and motion to strike the last answer as non-responsive and on relevance grounds. Mr. Patterson, I'd also note for the record that briefly before that last question and answer, the witness walked off screen for a moment. I just asked Mr. Patterson if we can confirm whether the witness had any communications or received any communications during that time.
Yes, I communicated with my air conditioning system and asked it to stop making it so cold.
Could you upload tab 10, please? Could you scroll through the document so the witness can see the entire document?
Mr. Patterson, I object to this document being shown. This is one of the communications from an AIS client to Mr. Kosnoff, it appears, and as well as Mr. Andrew Van Arsdale, and asked it to be taken down. Same objections as earlier.
There's, if you go to the end of the document to page Kosnoff, a number of zeros, 5, there's a waiver of the attorney-client privilege.
There are other privileges aside from the attorney-client privilege, which include common interest, work product, and I asked that it be taken down.
Okay, this is Joseph Gray. I just want to join Mr. Hogan.
Okay, you can take it down. Is it fair to say that with regard to any document between Mr. Kosnoff and his clients in which the client has specifically waived the attorney-client privilege, that you, Mr. Gray, and Mr. Hogan would object to those being made available today?
That's correct, yes.
That's correct for Mr. Gray, too.
Okay, and are you filing a motion for protective order?
We reserve our rights to do that. That's correct, yes.
And Mr. Wilkes, if I ask the questions of Mr. Kosnoff, would you instruct him not to answer?
I would admonish Mr. Kosnoff to observe attorney-client privilege to the extent that it is, and other privileges, to the extent that clients have not waived that privilege, but to the extent that the client has waived a particular document or a topic or a communication and other privileges, then I would admonish him that he is permitted to respond.
Mr. Kosnoff, have some of your clients indicated that they consent to your answering questions in this deposition regarding the ballot in this case?
Yes, and I got specific written authority for them, and they are in document production.
Okay. Mr. Hogan and Mr. Gray, I'm going to reserve on the question of whether the emails that we have referred to are privileged. And we'll keep this deposition open. And I'll give you an opportunity to file a motion for protective order.
Understood.
Mr. Could you, court reporter, could you, or the tech, could you upload number tab 14, please? Do you recognize tab 14?
I do.
And what is it?
It's a tweet I put out November 9th.
Okay. And I want to go to the middle of that document where it says replying to sex abuse attorneys. And I think there are 3 of those, and I'm talking about the first one for now. I just want to point out a rather egregious security error committed in an email that I suspect all other ERBSA clients received from Eisenberg Rothweiler this morning. Do you have an understanding of what that is?
Yes.
And what is that?
This is a thoughtful commentary by a survivor who pointed out to me how sending out usernames and passwords in a document is not secure.
And your understanding is that that's what the e-ballot had done?
Yes, I saw the e-ballot, and I saw that that's exactly what they were doing. They would send out an email to an individual with the e-ballot that had the username and the password. And you just clicked and it would take you to the e-ballot and you could cast it. So where did those emails go? Who would have had them? If they had, they would have been able to vote that ballot. And there would have been no way of knowing whether it was the actual survivor that was casting that ballot. I mean, it was mind-boggling.
No, my objection to the question and motion to strike.
I'd like this made an exhibit next in order. Could you upload tab 15, please? Do you recognize tab 15, Mr. Kosnoff?
Yes, I do.
And what is that?
It's a tweet in which I note the point I just made a moment ago. And having just been slammed by Miss Loria before the court and it being accused of misconduct, I wanted this to go out. And I asked her what genius on her side thought this was going to ensure ballot security. And these mail ballots are continuing to go out 4 or 5 times a day. They still haven't figured out how to stop it. I mean, this is like what people who want to sell you supplemental Medicare insurance do. I mean, but it's worse, and it's not funny, because these men have been through hell. They were asked to come forward by the Boy Scouts of America, and they did. And this is how they've been treated.
Object to the question and move to strike as non-responsive.
Could you upload, I'd like this designated the next exhibit in order. I'd like to ask that 17 be uploaded, please, tab 17.
This is Joe Gray. Just, can someone please let me know where we are in exhibit numbers? I'm trying to keep track.
So tab 15 was marked as exhibit 8.
Thank you.
Do you recognize this document, Mr. Kosnoff?
Yes, it's a tweet from me.
What were the circumstances under which you sent it?
Object to form.
Well, as soon as the e-ballot was out, the phone calls and the emails and the texts came pouring in, and I needed to communicate with a mass audience as best I could what was happening in real time. That I was receiving, in this case, a report that the e-ballot couldn't be completed on a smartphone, that it would reject. It wouldn't allow them to check the reject checkbox, only accept. One man later related a similar experience, and he said, finally I just gave up and I couldn't get it to accept it. And then I changed it from reject to accept, and then it accepted it and it went forward. Now I want to change it. I was cheated, I was tricked. They made me vote in a way that I didn't want to vote.
Thank you. I'd like to designate this the next exhibit in sequence.
Move to strike the last answer.
Could you upload to tab 18, please? Do you recognize tab 18, this document, Mr. Kosnoff?
Yes, I sent this out to let people know that they weren't alone, that this e-ballot thing wasn't functioning, and that they should work around it and send an email to bsaballots@omniagent.com, which was the only thing I could think of to do.
Thank you. I'd like to designate this the next exhibit in sequence.
I'd like to supplement that answer.
Yes.
I didn't understand why these men weren't getting the actual physical ballots, because I had thought that was part of the balloting order, and that Andrew would be sending those out. But these men are saying, I don't have the ballot, or they'd say, what's an e-ballot? I haven't received anything. How do I vote? So I probably cut and pasted that link to Omni ballots 300, 400 times in a week.
Have you had any communication?
Pardon me, counsel. Pardon me. Move to strike the last answer as non-responsive. And Mr. Patterson, we just object to the whole line of questioning and serial use of tweets and seemingly just asking Mr. Kosnoff to comment on them. Could you explain what the relevance is of this exercise?
Mr. Kosnoff, have you had any communication with Mr. Rothweiler or Mr. Van Arsdale regarding the communications you have had that indicate problems with the e-ballot?
Okay, I'll just note my objection for the record on foundation and other grounds relevance as well to the use of the tweets. Thank you.
No, nothing from them. And the last communication I had with Andrew was the text that you put up earlier.
To your knowledge, have any steps been taken by Mr. Rothweiler, Mr. Van Arsdale to correct any problems with the ballot, if there are any?
No, if anything, they continue to compound the problem.
And in what way do they do that?
Spam emails. People are reporting to me that they've already voted and they're still getting these spam emails. Each one of them feels like it's, they're reliving the event. It's traumatic to keep seeing these things popping up and up. The phone calls that I have returned were usually the ones that were the most desperate sounding. This was completely re-traumatizing. I can't overstate how wrong this was.
Could you upload document 23, please? Do you recognize document 23?
I do.
And what is document 23?
It was a way of, reaching out to my Twitter followers, many of whom are my clients. Some of them are other survivors represented by other attorneys. And it says what it says. I've received thousands of calls, texts, and emails. More than 1,000, yes. Thousands, I don't know. I haven't counted them up, but there's a lot.
I'd like to designate this the next exhibit in sequence, please.
Move to strike.
Second.
Could you upload document 24, please? Do you recognize this document, Mr. Kosnoff?
Yes.
And what is it?
It's also a tweet addressing the problem that people couldn't use the e-ballot, didn't get the e-ballot, didn't understand the e-ballot, and wanted a real ballot. And I told them to contact their lawyers, and if they don't have a lawyer, they can go here to Omni and request a ballot.
Same objection, same motion.
Oh, I should just add on this, the link there is to TCC BSA, which is the official BSA website. And it has how-to videos, explaining people what the ballot is and how to complete it and so forth. So that one was actually directing them to go to the TCC's site, which had some very useful how-to YouTubes.
Thank you.
Motion to strike. There was no question.
Could you upload document 28, please? I'd like, pardon me, with regard to the prior document, I'd like to have it admitted as the next exhibit in sequence.
Objection. There's no admission of evidence or documents at a deposition.
Attached as the exhibit. Document 28. Could you scroll through the document so the witness can see the entirety of it? Do you know what this document is, Mr. Kosnoff?
Yeah, I refer to this as my Sunday morning email, November 7th, which was what I was intended, which I used to respond to people that I didn't have the time or the ability to return all the calls, but I needed to communicate with them. And I needed to explain what had happened and to help them understand, what I was doing.
Is this a document that fairly states your objections to the ballot and your objections to the solicitation process?
It does, but the problems with the e-ballot got worse after this. And so it's probably not a complete listing of all the problems and objections that there were with this e-ballot, which I was, on the one hand, trying to communicate with thousands of upset survivors and at the same time figure out what this thing was.
Is this a document that you sent out to anybody?
Yeah, it was when I would get an email or a text, I would say, please read this. I can't call all of you back. There's a point here in the fourth paragraph, 1, 2, 3, 4, the single sentence. I said, first, it's not a real ballot. And that was important because this e-ballot email said e-ballot, and which in itself was highly misleading. Many people thought this was the ballot, that this was a court-approved official ballot. And, you know, whether that was the intent or not to mislead, it definitely misled.
Move to strike as non-responsive.
Mr. Patterson, when you finish with this document, is there any chance you could give me the courtesy of a 15-minute break here just to, I had thought we'd break for lunch and I just needed to, if that's possible.
Yeah, we can break for 15 minutes. Let's have this admitted as the next exhibit in sequence, and we'll take 15 minutes, take?
Great, thank you very much. I appreciate it.
Note the objection to the admission.
Okay, go off the record.
Yes.
Okay, and we're going off the record at 12:15. And we're back on the record at 12:39.
Okay. Before we ask a question, I just want to address the council the issue of the attorney-client privilege and the contention that emails that Mr. Kosnoff has had with his clients where the client has specifically waived the privilege, they object to their introduction in this deposition. And I want to propose a way of dealing with that I hope is acceptable to counsel, which is that we would ask our questions and put them in front of him, but we would seal that part of the transcript and give counsel an opportunity to get a protective order, which if they don't get, the matters would be open. But if they do get, then those matters would not be ultimately part of the official transcript of the deposition. Is that an acceptable way to proceed?
It is acceptable, Mr. Kosnoff.
It's acceptable to the ABA Law Group.
And that's acceptable to Eisenberg Rothweiler as well.
Okay.
Thanks.
Thank you. So then let's, just 1 second. Let me go off the record for 1 second, please. Let me. Okay, so let's go back and put up document number 10 again, please. And what is, Mr. Kosnoff, do you recognize document number 10?
Mr. Patterson, if I could just interject, just because it's a little unclear how you're labeling these. You were using tabs before.
Yeah, this is tab 10. Just that's the instruction to the tech because that's how they were indicated. We'll give this an exhibit number at the end of this colloquy.
That's fine. I just wanted to make sure that I was tracking along. Thank
Yeah, of
you.
course. Mr. Costa, could you scroll through the entire document, please, for the witness? Okay, Mr. Kosnoff, do you recognize this document? Mr. Kosnoff, you're muted.
It's an email to me along with the official committee, Andrew Van Arsdale, and it's blacked out, so I don't know who this person is, but I got his permission, and it's an example of hundreds of emails that I got expressing confusion and bewilderment about this e-ballot. And this one is relatively calm.
Can I direct your attention to page 3 of this document?
Yes.
So do I understand correctly that that in this part of the email that you requested that the sender consent to your revealing the substance of his communication with the?
That's right. And I used this paragraph pretty much boilerplate and got permission. And I only stopped doing it because I thought you had enough, but I could produce hundreds more like this letter.
And in the version that I have of the document, the name of the person who sent you this communication is blacked out, as is their email address.
Correct. And I think that my lawyer just did that out of just being careful.
So when I just like to ask you that when you sent the communication that is at the top of page 3 of this document, you sent it as a reply email to the original address that you had received this email from?
Correct.
Okay, could we list that as the next exhibit in sequence and mark it highly confidential, please?
And could I get that number, please, of that, what that exhibit number would be for my records?
I have it as marked exhibit 14.
Thank you.
Could you upload document 11, please? And could you scroll through it so the witness can see the entirety of it? Can I direct your attention to page 3 of the document? Is this a message similar to what we discussed with regard to exhibit 14, where you asked the sender of this email to consent to your revealing the substance of his communications?
That's correct.
And could you turn to page 4? And did you understand the message at the top of page 4 to be the consent for you to do that?
Yes.
Turning to page 1. Is this an example of the kind of email that you received in response to the e-ballot being sent out?
Yeah. Yes.
Thank you. I'd like to mark this exhibit 15. This is highly confidential.
I made an objection for the record. I just don't see it in the real time.
What was the objection?
I did not hear you, Mr. Moxley.
Oh, thank you, Madam Court Reporter. Just an objection to form, counsel.
Could you upload document 12, please? Could you scroll through it so the witness can see the entirety of it? On page 2, at the top, is that your message to the sender of this email asking for a waiver of the attorney-client privilege so you could reveal the substance of the communication?
Correct.
And at the bottom is a response to that email that you sent?
Correct.
And turning to page 1, is this an example of an email that you received from a client in response to the e-balloting process?
Check the form.
It is.
I'd like this to be designated Exhibit 16, please, and it is highly confidential. Could you upload document 13, please? Could you scroll through it so the client, pardon me, the witness can see the entirety of it? Let's go to page 4 if we can. Page 4 at the top, is that your request to the sender of this email for their consent to your waiving the privilege with regard to the communication?
Yes, it is.
And at the bottom, you took that to be the permission to do so?
Yeah. Yes, I did.
Could you describe this document for me, please?
Check the form.
Can we go back to the beginning? Well, this is somebody who's expressing sympathy for me getting kicked around, I guess, encouraging me to hang in there. And then I guess it was 2 days later on November 10th, I just wanted to touch base with you and tell you about an email I received today. I took a screenshot and sent with this email. You may find it interesting. And it was a screenshot of the e-ballot that this client received.
I'd like this to be designated the next exhibit in sequence, which I think is 17, and it is highly confidential. Could you upload document 16, please? Mr. Kosnoff, is this a communication you received from someone you understood to be a client of yours?
Yes.
Could you scroll through this document so the witness can see the entire document? On the very last page, Mr. Kosnoff, did you understand the message there to be that you could waive the attorney-client privilege and make the exchange public as you see fit?
Yes. Yes.
Note my objection to form, please.
Mr. Kosnoff, did you receive, this email indicates that the person had received multiple solicitation emails from EIS with regard to solicitation. Is that a fair characterization of it?
No, this was not AIS. This was the coalition.
Okay. And the email says, "This is the 4th solicitation email I have received. I feel compelled to reply." Did you receive other communications from clients indicating their concern about receiving multiple solicitations?
Yes, and they got increasingly angry and upset.
Who's the they in that sentence?
The survivors who had received the initial e-ballot had whatever experience they had with it, but then were bewildered why they were receiving 4 and 5 of the same emails with the same solicitation over and over and over again. They were reporting, and I assume this is probably true of all the emails, that 4 or 5 of these went out a day to the clients represented by the law firms who made up the coalition.
When you say the coalition sent this email, was it your understanding that the coalition was performing the solicitation and not Eisenberg Rothweiler?
It was all of them. They each were using this company, this e-ballot company, to send out e-ballots.
Well, thank you. I'd like to have this designated as an exhibit in the next number in sequence, which I think is 18, and it is highly confidential. Could you upload document 20, please? Could you scroll through it so the witness can see the entire document? On page 3, did you take the communication there to be consent to use this material and waive the attorney-client privilege with respect to it?
Yes, I did.
You turn to page 1, please. I believe previously you had testified that some people had complained that the document would not, pardon me, the e-ballot would not permit a reject vote. Was this an example of the communication of that kind that you received?
Yes.
Did you receive more than one of this kind of communication?
Yes.
Objection. Mr. Patterson, I would ask you to go to the end of this document because it doesn't appear that this document is a complete reproduction of the entirety of the communication. It appears that it's cut off at the very end on Bates number, looks like 15, where it reads, "But does this mean my name would," and then it stops.
Mr. Kosnoff, do you see where Mr. Hogan is referring to?
Yeah.
You have an understanding of why some of the text is cut off at that point?
I believe because the person didn't complete their sentence.
To your knowledge, is this the entirety of the document that?
Yes, it is.
Objective form.
Mr. Kosnoff, did you delete any portions of this document other than the blacked out portions?
I didn't even do the blackout. My lawyer did. I didn't change one character on any of these emails.
Okay,
What you see is what I received.
thank you. I'd like to designate this the next exhibit in sequence, which is 19, and it's highly confidential. Can you upload document 21, please? Is this an email exchange? Just let me strike that. What is document, this document?
Can you make it a little bigger for me? Okay. Yes, I recognize this document.
And what is it?
This was dated November 6th, and I wrote to Mr. Lucas, and I said, John, this man said he selected reject, but then showed him as accepting. He's willing to sign an affidavit. And then Mr. Lucas responds, the screenshot states that the survivor received copies of the solicitation materials, but also a copy of his ballot. Can you please ask him if that he really received a copy of the ballot? From this screenshot, it appears that Ken is not using a master ballot.
This is an accurate copy of a communication that you had with Mr. Lucas?
It is. Let's scroll down a little bit because it looks like he responded or I responded to him. John, this man said he selected reject, but then showed him as accepting. He's willing to sign an affidavit. This e-ballot, after you voted, was supposed to generate a quote unquote receipt, which was the last page that confirmed how you voted and when you voted, date, time, and so forth. And I guess it was coded for this particular, for each individual. And here he says that he checked reject, and the receipt he got showed him as accepting.
Did you receive any other
Pardon
communication?
me. I moved to strike as non-responsive. Thank you.
Did you receive any other communications of this kind from people indicating that the ballot did not properly record their intent?
Yes, multiple.
Thank you. I'd like to designate this the next exhibit in sequence, which is 20, and we can designate this as highly confidential. Could you upload document 22, please? Could you scroll through it so the witness can see the entire document? At the end of this document, did you understand the message to be that you were permitted to use this email exchange at a deposition and waive the privilege?
Yes, I did.
And what is this document, Mr. Kosnoff?
Well, this is, representative of the mass confusion that this e-ballot created. And the only solution I could think of was to bypass it entirely and advise people to go to Omni and request them to send them the official ballot.
Turning to page 2, about 2/3 of the way down, there's a passage that begins, "Hello, Timothy. When filling out the electronic form, I noted the following. Your electronic submission is not working correctly due to the following reasons," and it gives 2 reasons. Do you see that text?
Yes, I do.
What did you understand the complaint to be from the person who authored this part of the email?
That the electronic submission process was not working, and that she got a message, or he got a message that advised that they had not checked the 3,500 checkbox. And she says that in the paperwork I'm supposed to sign states that I have. I did not check the box for the optional release election, yet the final paperwork that I am supposed to sign states that I have. There seems to be errors with the electronic form. I have emailed Eisenberg Rothweiler.
Thank you. I'd like to mark this the next exhibit in sequence, which I believe is 21, and it'll be designated highly confidential. Could you upload document 29, please? You scroll through it to the end, please. Did you understand the message, second from the bottom on the last page of this document, to be your consent to use this information in this deposition?
Yes, that she was consenting to use this email exchange.
And what is this document, Mr. Kosnoff?
Well, it's an email between me and this person. And if we go back to the top, I received so many of these, I was blurry-eyed. It was an incredibly intense period. It still is. But I got back to her or him, and he or she expressed their appreciation. They wanted to know specifically how to complete the ballot, and if they wanted to reject it, how to do it. So I guess this is an effort to try and coach her through it. It also reflects many comments that they called Eisenberg Rothweiler and didn't get any calls back, that Andrew Van Arsdale had gone missing in action. And, I was left to man the fort by myself, because they were confused, they had questions, and I was the only person that said, call me. Here's my email address, text me. And I had no idea what I was signing on for.
Thank you, Mr. Kosnoff. I'd like to designate this as the next exhibit in sequence, which I believe is 22, and it's highly confidential. Could you upload document number 30, please? Could you turn to page 2 of it, please? Did you understand the message at the bottom of page 2 to be a waiver of the attorney-client privilege to permit you to disclose this information?
Yes.
Turning to page 1. At the top of it, the text following, "Hi, Tim," it says, "I would very much like to talk to you. I'm getting pressured like you would not believe to take this deal," and so on. Did you get emails and communications from client survivors who indicated they were being pressured to vote yes on the plan?
Yes, yes, I did.
And who did you understand they were being pressured by?
Well, I later received similar emails saying that they were getting calls from Eisenberg Rothweiler, specifically Josh Schwartz, trying to convince them to change their vote from reject to yes after they had already cast their vote. And I got multiple emails reporting that. And perhaps the most troubling was one I received just a couple days ago, which is that this client who had voted to reject was getting calls from Mark Byrne, who doesn't even represent this man, pressuring him to change his vote to yes. So evidently, Eisenberg Rothweiler and their pressure campaign on survivors is recruiting other law firms in the coalition and giving them permission to put pressure on my clients without my knowledge or permission.
Thank you. I'd like this designated as Exhibit 23, and it's highly confidential. Could you upload document 31, please? Scrolling to the end of it on page 4. Did you take this communication to be a waiver of the attorney-client privilege to allow you to disclose these materials?
Yes, I did.
And what is this document, Mr. Kosnoff?
Well, it's a, let's see, is this, yeah, this is an email exchange with this client. And she's reporting, or he's reporting, receiving Eisenberg emails daily, which he describes as abusive. He said he received his ballot in the mail today, completely confusing. The opt-out section is not expanded in any simplified form whatsoever. So I'm not sure exactly whether he's referring to the email ballot or which ballot, but obviously a confused claimant.
I'd like to mark this next in sequence, which I believe is 24, and it's highly confidential. Could you upload document 32, please? Can you scroll to the end, please? So I'd like to take this document down, please. Let's go to 33 if we can, please. Could you scroll down through the document so the witness can see it? Turning to page, oh, it's longer, still more. Could you turn to page 3 of it, please? Could you You understand this communication to be a client's consent to waive the attorney-client privilege with regard to this communication?
That's correct.
And what did you understand this communication to be?
Well, this is a man who recognized how wrong a ballot of this nature was, with all of its solicitation language right on the face of the ballot, with nothing from me, and he's angry about it.
Thank you. I'd like to designate this the next exhibit in sequence, which is 25. It's highly confidential. Could you upload 34, please? You scroll through it so the witness can see the whole document. Do you understand the communication at the end to be consent to waive the privilege so you could disclose this email?
Yes.
And what is this communication? What is this document? Pardon me.
Well, this is an email exchange with this person expressing confusion. If you'll go back up to first or second page. We are really confused. Sounds like there was a disagreement between the firms on path we need to vote for. I do not know. I do know that we are disappointed with compensation amount. Many years of suffering by all of us does not seem to be in play. Really sad. And this was a person that I couldn't be sure was actually a client. So I think I asked if this person is a client, confirmed that they were, and then asked them to waive the attorney-client privilege.
I'd like to designate this next number in sequence, which I believe is 26, and it's highly confidential. Could you upload document 35, please? Scroll to page 2, please. Did you take this message at the end to be consent to waive the privilege and allow you to disclose these materials?
Yes, I did.
Can you describe this document for me?
Well, it's an email expressing frustration that they received a confusing, lopsided, one side only presentation of what they needed to vote on. And this person was expressing their displeasure with that.
And I take it your understanding was this came from a client of yours?
Yes.
Could I have this marked as number 27? It's highly confidential. Could you pull up document 40, please? Scroll through it so the witness can see it. Did you take? I take it this is a printout of an IM, an instant message exchange.
Yeah, or text, but yeah.
Text on your phone.
Correct.
And I take it you take the message at the very end of it on the last page to be consent to waive the privilege so you can disclose it?
Yes.
Turning to page 1. Could you read the gray text at the top, please?
Good afternoon, sir. You submitted this number in the email you sent me, which I believe was the Friday night email that went out from Pachulski Stang. He says, I voted yesterday and rejected the offer, and today I got a call from Josh Schwartz asking for me to reconsider. Is that legal? And I really didn't know the answer to the question. I said legal, probably, ethically, probably not.
Do you know who Josh Schwartz is?
Yeah, he's a partner at Eisenberg Rothweiler.
Did you receive other communications from clients indicating that they had voted to reject the plan and then had follow-up conversations initiated by lawyers at Eisenberg Rothweiler?
Yes.
Many?
You know, I haven't even gone through all the emails and voicemails. So, I mean, it's this, there were other examples of this, but I haven't done a complete inventory of all the communications that I received between November, 5th or 6th and today, mostly because I've been too busy trying to respond to them.
I'd like to designate this as the next exhibit in sequence, which is 28, and it's highly confidential. So with regard to the highly confidential exhibits that we've discussed, they will not be filed with the court except under seal, pending a motion for protective order by counsel who object to their production. Can we agree on a reasonable period of time that if you don't have a protective order by a certain period that the highly confidential designation can be released?
This is Joseph Gray. I would prefer that we don't burden the court by making, in other words, the deadline ought to be by the time we file a motion. And what I'd like a chance to do is this, talk with Mr. Hogan offline. Agree to a deadline for that.
I think we need a deadline of some reasonable period. This can't.
Understood. And I'm willing to accept a deadline for us. I just don't want to impose it on the court by saying we have to have an order by this time.
Okay, well, I'll tell you what, that completes my questioning. And so I think the deposition is still open. I think Mr. Scavone had questions he wanted to ask. I would like to come back at the end and have agreement on a date by which the protective order has to be obtained.
I understand. I understand the request.
Okay.
Mr. Schiavone, would you excuse me for just a couple minutes? I need to take a bathroom break.
Oh, that's fine. That's totally fine.
Going off the record at 1:21.
Recording stopped.
Can we talk off the record? Because
Stand by.
Recording in progress.
And we're back on the record at 1:26.
okay. All right. Thank you, Mr. Kosnoff, for being here today. I appreciate that. Mr. Kosnoff, are you licensed in any states other than Washington to practice law?
No.
Okay. Did you retire in 2017?
I retired in 2018. I wrapped up my final cases in 2018 with the intention of formally retiring from the practice of law December 31st, 2018.
And did you retire in December 2018?
For about 10 days.
I see. And then what happened? You unretired after that?
Yeah, I contemplated that Wall Street Journal article. I thought about it. I paced. I considered what it would mean to jump back in and made the decision that I wanted to, and if I could find lawyers that would do it with me, that I would do it. And so that was the genesis of my association with Eisenberg, Rothweiler, and ABA.
Did you represent in any court proceedings that you had remained retired?
I'm sorry, could you say again?
Yes. Did you represent in any court proceedings that you had remained retired after retiring in December of 2018?
So is the question, after December 31st, 2018, did I continue to represent people?
No. Did you represent in any court proceedings that you had remained retired after December 2018?
Well, I think you're referring to my divorce dispute with my ex-wife. And that was a dispute in part around the language of the separation contract.
Okay. And did you represent in that proceeding that you remained retired?
I didn't represent that I remained retired. I represented that I had retired and that my obligations to her ceased on December 31st, 2018.
Okay. And that was as part of an effort to escape having to pay any spousal support to her in connection with the Boy Scout case?
Judge, this is far outside the scope of any reasonable discovery. Go ahead.
It was to enforce my rights under the separation contract.
And you were found in contempt by the Washington State Court of Appeals in connection with that case?
No, sir.
Okay. Did the Washington State Court of Appeals uphold the finding of contempt in that case?
I think they found that I was obligated to pay her until I surrendered my law license. And I believe that the contempt was purged upon payment into the registry of the court, what the court determined I owed.
The court upheld the contempt finding itself, the Court of Appeals, right?
I don't have the opinion in front of me. I don't think that's what it held, but if, it says what it says.
Okay. And the court also awarded attorney's fees in that case, right?
Object to this whole line of questioning.
And at the time you retired in 2018, had Kosnoff law been created at that point?
Kosnoff law had been in existence since 2011.
Okay.
I took a partner on, and it became Kosnoff Fazy. Mr. Fazy quit the partnership in 2016, and I resumed practicing law under the name Kosnoff Law.
In 2018, did Kosnoff Law have any employees?
Me.
Okay. And after 2018, did Kosnoff Law have any employees other than yourself?
Let me correct that. I had two residents of Puerto Rico who were employees they were employees in Puerto Rico.
That was in 2018?
Yes.
Okay. And did they continue as employees in 2019?
They did. I believe I terminated them in 2020. Could have been 2019.
Okay. Did they work on the Boy Scout case?
No.
Okay. Where did you maintain your office, your law office, in 2018?
My law office existed in cyberspace. Wherever I had a cell connection or internet connection, and I could do my work, I was practicing law. So that could have been Puerto Rico, the Virgin Islands, the Turks and Caicos, the Bahamas, South Florida, and eventually Johns Island, South Carolina. And now, because my home, my boat is back in Washington State or in Washington State, my office is there. Right now, I'm in Palm Springs and I'm practicing law. So you could say that I'm practicing law in Palm Springs too.
Did you sail your boat through the Panama Canal up to Washington State?
No, I'd still be on it if I had wanted to do that. It was put on a cargo ship and delivered to Victoria, British Columbia in January, I forget with COVID, either 19 or 20.
Okay. Did you, over the period from 2019 through today, have you maintained a law office anywhere other than cyberspace?
Well, a physical office, I guess, no. Have any of us in the pandemic over the last 2 years? I mean, I know you have an office in a tower in Manhattan, but it seems like whenever I see you, you're not there. So I could ask you the same question.
So it's fair to say you don't maintain an office. You haven't maintained an office between 2019 and today in any physical location.
No, that's not true. And I think I've explained that.
Okay. What are the physical locations where you've maintained an office while you've been working on the Boy Scout case?
Okay. As I said, I have lived for 7.5 years on my sailboat. It is a 55-foot blue water cruiser. I have worked on cases on her in Annapolis, Fort Lauderdale, Palmas del Mar, Puerto Rico, St. Thomas, St. John, St. Croix, the Dominican Republic, the Bahamas, South Florida, and then outside of Charleston, South Carolina, until I moved, had the boat shipped to Puget Sound.
Do you maintain an office in Houston?
No, as you understand, a sailboat is mobile. It moves. I've had her at various marinas at different times, sometimes days, sometimes weeks, sometimes months, but it's not practical to constantly have forwarding mail addresses with the US Post Office. So the Houston address that you've been interested in is, it's a service, and that's where my physical mail goes. And whenever mail arrives, I'm notified by email. I can go in, I can look at it, have it scanned and emailed to me, or they can put it in an envelope or FedEx and forward it to me wherever I happen to be. It was a practical solution for somebody who lives on a sailboat.
Do you have a office in San Juan, Puerto Rico?
There was a, what is the name? You probably know it. They're executive, what do they call them? I think, is it Regency or Regal? They have them all over the world. And they have answering services, mail service, and conference rooms, and offices that you can use on a hourly basis. I had that as my official Puerto Rico business address, but I was rarely, if ever, there.
It was the San Juan address really sort of a mail drop for you?
Well, not really, because I don't know if you've ever been to Puerto Rico, but it's. I tried having a mailbox in Puerto Rico, and it was problematic. So I switched it to the Houston service, and then I could be satisfied that I was getting my mail daily.
How many times did you work out of the Puerto Rico facility in 2020?
Well, in 2020, I didn't spend a single day in Puerto Rico because of the pandemic. And so, although prior to that, I had been a bona fide Puerto Rico resident, but I did not qualify in 2020. And I notified Puerto Rico that I was no longer going to continue to be a resident of Puerto Rico, and that I would be changing my residence to Washington State, as it had been before I moved to Puerto Rico.
How did you come to choose to list San Juan as an office address on the AIS retention letter?
Well, it was technically my physical office presence, such as it was in San Juan. But my relationship with my clients has been for 7 years largely email and telephone. I haven't actually even met my own lawyer in this case in person.
How many cases did you try to verdict against the Boy Scouts?
I'm sorry, would you say that again?
Yeah. How many cases did you try to verdict against the Boy Scouts?
I didn't have to.
Okay. Does that mean 5 or 6, or how many does that mean?
It means they settled.
Okay. So is it fair to say that you've never tried a case to verdict against the Boy Scouts?
Unless I'm having a senior moment, I can't remember one, no.
Okay. How many?
I'm sorry. He froze. I did not get that answer.
I'm having a senior moment. My memory is pretty good, but I'll be 68 next month, and well, that's life. But yes, I don't believe I've ever tried a case against the Boy Scouts. I don't believe many people have.
Okay. And I was asking just about how many you tried to verdict. Have you never tried a case against the Boy Scouts?
Have I litigated against the Boy Scouts?
No. Have you given an opening statement in a trial? Let's just start there. I mean, have you ever done a trial against the Boy Scouts? Actually started a trial?
No.
Okay. So it's fair to say you've never given an opening or closing statement, or even started a trial against the Boy Scouts, right?
Or the Salvation Army, or the Jehovah's Witnesses, or Big Brothers Big Sisters, a whole number of defendants that I have sued and obtained favorable settlements. So you're correct.
Okay. So it's not just you spoke earlier about some of these other organizations. You've never actually started a trial against the Mormons, or in fact any church, right?
That's false.
Okay. So what was the list you just went through? You haven't actually, did you start any trials against the Mormons?
Oh, yes.
Okay. And how many trials did you give opening statements for against the Church of Latter-day Saints?
Well, in the Jeremiah Scott case that I talked about that settled in 2001, we were in motions in limine, And we were ordered into mediation, and it settled for $3 million in August. I gave an opening statement against the Mormon Church in the King County Justice Center in Kent, Washington in 2005, which resulted in a $4.2 million verdict. Let's see. I've tried cases against the Archdiocese of Seattle.
Let's just focus on the Mormon, the Latter-day Saints first. So against the Latter-day Saints, there was one case where you gave an opening statement. You started a trial, gave an opening statement.
Yes.
Were there any more?
Well, I think I'm okay as a trial lawyer, but in going up against the Mormon Church, I like my front line to look like Notre Dame's. And that means putting up a lawyer who frankly is a better lawyer in front of a jury than I am.
Okay, I'm not being judgmental. I just want to just get the numbers down, right? So you've never started a trial against the Boy Scouts, right?
I think I answered that.
Okay. And the answer was you haven't, right?
I didn't have to. They settled.
Okay. But whether you had to or not, you in fact have never given an opening statement in a trial against the Boy Scouts, right?
Thank you. You've asked that like 4 times. He's already answered that.
We haven't got a yes, no, that's all.
Yes, you have. He said he hasn't. He's already told you that.
Okay. And against the Church of Latter-day Saints, there was this one case in 2005 in Kings County where you gave an opening statement, but that's the only case, right, where you ever started a trial against the Latter-day Saints?
No, they got reasonable after that.
Okay. So there were no other cases where you started a trial, right?
Well, no, there was one just in 2018 in Martinsburg, West Virginia, involving, I believe, 11 minor clients, the youngest being 4. And that was tried for 3.5 months. And
you tried that case?
I was one of the attorneys, yes.
Okay, all right. And what was the name of the lead plaintiff? Do you remember?
Jane Doe.
Okay. That was 2018. Who were the other plaintiffs in that case? Plaintiff lawyers. Plaintiff lawyers.
Well, our trial team consisted of me and Carl Kravitz of Zuckerman Spader and 2 of his partners. That was us.
Okay. Have you had any cases against the Boy Scouts that you brought dismissed?
Let me think how to answer that. There were, and you're testing my memory, but there were some adverse rulings in a case that I had involving 12 plaintiffs raped by 12 different scout leaders. And the judge in that case ruled that the Boy Scouts of America did not have custody and control of the scout troops. That was the responsibility of the chartering organizations. And therefore, since many of the chartering organizations, perhaps all of them, were defunct or non-existent, and the Boy Scouts could not be held liable, at least on our theory of liability, nor the consuls, we had to non-suit those cases, dismiss them. I think we may have settled a few for some modest amounts. But yeah, that was about the time I started thinking about retirement.
In what state was that in, Mr. Kosnoff?
It was in Seattle.
Okay. And were those, did you say 12 cases, 12 individuals?
Maybe 13, maybe 11.
Were they all in the same case or were they separate cases?
It was all one filing.
I see.
It was like, I think the title was Boys 1 through 12.
Okay. And have there been other cases? Is that other cases were against the Boy Scouts that have been dismissed for failure to prove liability?
No. I had used the same theory successfully and obtained substantial settlements on behalf of clients in the decade prior to that. But there was this unfortunate decision by this federal judge that threw a bone to the Boy Scouts, I guess you could say.
Are you aware of any other situations ever where cases have been dismissed against the Boy Scouts for failure to show liability?
Well, I'm aware that there are, because it's a strangely structured organization where you've got all the power and the authority residing in the BSA National, and yet you have the at-fault party, the charter scout troop sponsored by some church or Kiwanis or whatever, with limited or no assets, maybe some insurance, and they were the ones that were liable. So the Boy Scouts of America have, I think, succeeded on that theory. Generally, there's no daylight between BSA National, the local councils, and the charters, but they will argue out of one side of their mouth that they're not responsible, and on the other, they'll argue that responsibility lies with the charters. So to answer your question, I do track litigation around the country, and there are lawyers, I guess, that have brought cases and maybe they didn't understand quite what they had, and they were not successful in motion practice, and that was the last we heard of them.
So there have been other cases where the Boy Scouts have been dismissed as a defendant in the sexual abuse cases, right?
That's true.
Okay. And how many jury verdicts has Mr. Van Arsdale racked up against the Boy Scouts?
You'd have to ask him.
Okay. Well, as your co-counsel, did you know whether he's ever tried a case against the Boy Scouts?
I was pretty sure that he'd never tried a case against the Boy Scouts, and I wasn't sure whether he'd ever tried any case.
Is it fair to say that you knew Mr. Van Arsdale had never tried a case in his life?
I didn't know that. He was, the time I met him, he was late 30s. He was a lawyer, licensed in California and Montana. I assumed that he'd been a lawyer for a while. And it really wasn't until your pleadings, Mr. Schiavone, that I learned that he'd only been admitted, I think, as a lawyer in 2017 or 18. But that was Andrew's experience as a trial lawyer was not the value add that he brought to this case.
Before you formed AIS, did Mr. Van Arsdale ever bring a lawsuit against the Boy Scouts?
Hold on one sec. Let me just object to the characterization of formation of AIS, and just give me a continuing objection on that, and I won't keep jumping in. But it was never formally formed, and you know our position on that. Would you just give me a continuing objection on that, and I won't continue to jump in?
If you want to just remind everyone that AIS is a non-existent legal entity, you can do that as often as you want.
So you won't give me a continuing objection on that? Come on, she told us to be civil, Tank.
I just like to, this is Joe Gray. I just like to object to the form.
Mr. Kosnoff, before you went forward under the banner of AIS, can you tell us, did Mr. Van Arsdale ever have a lawsuit that he brought against the Boy Scouts?
Objection form.
I don't know.
Did you review the advertisements that Mr. Van Arsdale ran for AIS?
Initially, I collaborated with him in writing a script. After a while, I deferred to Andrew, who was very good at writing and producing those kinds of television spots. And sometimes I wouldn't see them because I don't watch TV, but I might see it on YouTube and watch it. That could be a month or 2 or 3 later. But he was doing a good job with it, and I didn't interfere. It was mostly a repetition of the themes that we had worked out together at the very beginning.
And you of course, reviewed the AIS website, right? And were familiar with the contents of it.
Well, not really, because frankly, we were so busy talking to clients that I didn't have a lot of extramural time to check out AIS website. I knew we had one. It was a way for clients to go and also contact us in addition to the TV, but there was Facebook, and I think Andrew's a full service communicator, and you can find Andrew Van Arsdale and AIS in a lot of places on the internet.
Right, he's pretty good at touting things, right?
I'd say so.
Okay, is one of the things that that you were touting on the AIS webpage was that Mr. Van Arsdale had in fact handled thousands of cases before the Boy Scouts?
I did not own the AIS website. I did not review it. I didn't put up content material. I think there was a commercial that I appeared in that was placed on there, but no, I had better things to do than monitor Andrew's daily activities.
Okay. But the people who were being recruited to become AIS clients, they were coming through that AIS website, weren't they?
Well, I presume that some of them did. The TV ads would have I believe it had the website. It also had the phone number. So there were multiple ways that victims could contact us. That's about all I can tell you.
And you did know that Mr. Van Arsdale, he didn't have any other lawyers working with him at AVA Law, right?
Action form.
I don't know, but I don't think that's true.
Yeah, all right. So were you under the impression that AVA Law had other lawyers other than Mr. Van Arsdale working there?
I knew that he had a partner, and I knew that he had some excellent paralegals working on our cases, and I communicated with them. So in terms of the task that AVA was expected to perform, I thought they were doing an excellent job.
Okay. AVA Law is a California professional corporation, isn't it?
I don't know.
Okay.
I think Mr. Schiavone, Andrew lives in California, and I think that his staff, and I think it's north of 50, are located in Billings, Montana. He manages them remotely.
Have you heard of a company in Billings, Montana called Reciprocity?
I know the word reciprocity, and all I can tell you is that when I contributed money to run television spots. I either wrote the check or charged it, and it showed up on my credit card as Reciprocity Industries.
Right. So is it fair to say that you knew that Mr. Van Arsdale, he had a legal corporation called AVA, and he separately had a business called Reciprocity?
I didn't know one way or the other. I assumed that they were perhaps, overlapping entities. I didn't know. I didn't really care.
You thought Reciprocity LLC and AVA PC were overlapping entities?
Yes, that Reciprocity Industries was the company owned by Andrew and a silent partner, I don't know, he never shared it with me, that handled the intake and processing of clients that came to us through the marketing program, which Andrew oversaw.
So Reciprocity Industries, it's a claims aggregator, isn't it? It's not a law firm.
Mr. Schiavone, I didn't even know the word aggregator or what it was until I started hearing you in open court. All I know is I was working with a lawyer who I trusted, who had a competent staff. I didn't care exactly where what name was on the paychecks. I cared about whether they were hardworking, diligent, honest, qualified, and could deal sensitively with these victims as they came in. So that's all I can tell you.
What did you think when the business was called Industries, Reciprocity Industries? You thought that was a law firm?
I don't know what I thought. But it may have, no, if you're a law firm, you've got to say, LLC or PLLC or, solo practitioner. But I'm not aware of it being a crime to run a law practice and have a separate corporate entity contractually involved in helping you process claims that come into your law practice.
Did you ever visit the Reciprocity Industries offices in Montana?
Mr. Schiavone, I have spent a lot of time in Montana, and it's beautiful for about 1 month out of the year. But no, I never went to Billings, and it's too cold.
Okay, so it's fair to say also you've never met any of the people that work there at the Reciprocity Industries office?
No, but I talk to them almost daily.
Okay. Can you tell us, can you identify one of them that, is in fact a social worker?
Now there has been some turnover, and I'm not the best with names, but I would say the top person he had and who I had the most contact with was a woman named Donnell, Donnell. And, the summaries that I would receive daily would come from her. And if I had a question, I would communicate with her by email, occasionally by phone. But there were others, or Brianna. He had some really good tech guys. He mentioned their first names. I never met them.
And is the way it would sort of work is that he would hire people for $15 an hour to work answering phones in Montana, Mr. Van Arsdale?
You'd have to ask Mr. Van Arsdale. I don't know what he paid them, but that's a good question for him.
What did you do to apprise yourself of the qualifications of the people that were working in Montana?
Well, I just judged them by the quality of the work product that I saw coming from them. And conversations with Andrew, he thought, and I think he was right, that there's a lot of people that like to live in Montana. The cost of living is lower there. It's beautiful. And he was able to assemble a team of pretty smart people right there in Billings, Montana.
Did he hire people out of high school to work on the Boy Scouts case to answering phones?
Well, I don't know, but if he did, does your firm?
No.
No? You only hire college graduates to answer the phone?
Do you know what a call center is?
Sure, everybody does.
Okay. Was Mr. Van Arsdale operating a call center in Montana to intake Boy Scout claims?
You know, Mr. Schiavone, you play with language. So I've heard this described by you in various ways: call center, boiler room. You can denigrate Andrew and the hardworking people there. But when you look at the product that came out of there, it was pretty damn good. And I'd put it up against the work product at your law firm.
Was Mr. Van Arsdale operating a call center in Montana for the Boy Scout case?
I don't know what you mean by a call center. Calls came in there. People answered the phone. Was it centralized? Yes. Were there calls? Yes. Does that make it a call center? I don't know.
Okay.
When I think of call center, I think of getting a call from somebody from India who's asking me to,
Sorry, you froze there. I'm sorry, you froze. I think of getting a call from somebody.
Yeah, in a foreign country that's asking me to, subscribe to something. So no, I think it was a place where people were trained and qualified and sensitive enough to be able to handle calls coming in from severely emotionally and psychologically injured men.
Well, there's no question in the first instance that you knew that Mr. Van Arsdale, through Reciprocity Industries, had a center staffed with people to answer phones in Montana on the Boy Scouts case, right?
No, I don't know what all went on in
Okay.
facility.
Okay. Would it be fair to say you don't know how they would train any of the people in Reciprocity?
Well, we talked about it. I told him what my expectations were and coached him. And I know that he had regular weekly or maybe twice a week telephone training sessions with his staff because he mentioned that to me.
Oh, he was there in Montana?
No, he was doing it remotely from San Diego.
Okay. And were the staff trained to fill out the proofs of claim as people called in Montana?
I'm sorry, you froze again. Was the staff trained to?
Were the staff at Reciprocity trained to fill out proofs of claim in Montana?
I'm going to object as to the form of the question because there's no temporal construct as to when. It would be helpful if you would articulate when this.
Were the staff at Reciprocity in Montana, were they trained to fill out proofs of claim before the bar date ran?
I don't know. I think much of that work was done by Eisenberg Rothweiler's attorneys and staff. Not all of it, but a big part of it.
Okay. How do you know that?
Well, because we had weekly, sometimes daily discussions about the workflow and the process And it was very stressful the last couple of months before the bar date. Claims were coming in at a ferocious rate. Rita, the attorney at Eisenberg Rothweiler, headed up a team, and they kept adding people to that team to keep up with it. And then Rita got COVID and was out of action for a week. So we had to redistribute responsibilities. And I think some of that went back to Andrew. So that's the extent of my recollection about that.
How many years had Rita been out of law school?
Well, I don't know, but she was a woman in her late 30s, early 40s, and she was no kid.
Was she a lawyer?
She was a lawyer.
Okay. And Andrew's people in Montana, were there any lawyers there?
You're going to have to ask Andrew, because I just don't know, and I'm not going to give you an answer that I don't really have any basis to give.
Okay, but they were filling out proofs.
I'm sorry, he froze again. I'm not going to give you an answer that I don't really
have a basis to give.
Okay, so were Andrew's people filling out proofs of claim in Montana?
I don't know exactly how the workflow was going. I think many of the proofs of claim were going to Eisenberg Rothweiler, and then they were transmitted back to Andrew so that he could send them out for DocuSign, because he had the technical equipment to be able to do that.
And the DocuSign was something that Reciprocity was operating to sign the proofs of claim with?
Yes, but perhaps Eisenberg too. We were racing against the clock. We were trying to get signed proofs of claim back from clients, and it was a daunting task with 15,000 individuals. So at some point, we made the decision that we as attorneys could not blow the bar date for these men, and that if we couldn't get their signatures, that we would DocuSign them as attorneys. And then we would go back after November 16th and gather more information, file amended proofs of claim, and get signatures on the amended proof of claims from the clients. But in early November of 2020, we didn't have the luxury of time, courtesy of the Boy Scouts and the claims bar period set by the court.
So one of the things that was done to get the proofs of claim in were that in some instances, lawyers for AIS signed the proofs of claim in mass, right?
Objection, form.
When you say the lawyers of AIS, as you well know, AIS was a shorthand term that was pulled from a URL that I registered. Other lawyers had used something similar. I thought it was catchy. Abused in Montana, abused in Milwaukee. So if you go and look, you'll see a lot of abused in and sexual abuse cases. So we became abused in scouting, but we were independent, 3 law firms collectively representing our clients.
Is there a place I could find in the AIS website, the AIS advertisements, or the AIS retention agreement where you told clients that you were 3 lawyers acting independently? Where do we go to find that?
Well, I don't know, but I don't see the point.
Thank you. Sir, at any point in time, did you run ads where you told people that they were joining and becoming members of an organization when they became part of AIS?
No, sir, I did not.
And are you sitting here today under oath telling us that you're unaware of web advertisements run by AIS where your clients were told that they were going to join and become a member of AIS?
I'll object to the form. It also is different than the last question, so it's unfair, but I'll object to the form.
Mr. Schivoni, if you've got such an ad you want to show me, we can have this conversation. But my experience with you, sir, is you frequently make baseless accusations. So show me the evidence and we'll talk about it. Okay.
Well, are you aware of look, it's totally okay if what your view is that Mr. Van Arsdale was doing this without you.
I'm saying you've made an assertion. Show me the proof.
An objection, Mr. Schifoni, you can't testify. It's not time for you to do that.
Okay. In agreeing to be part of AIS, were your clients becoming members of an organization?
No, you've seen the retention agreements, and they say that you are hereby retaining AVA law, Kosnoff law, and Eisenberg-Rothweiler. They couldn't be more explicit.
Why is it that you didn't put in your retention agreements any disclosure for associated with the risks of a multi-party retention?
Would you say that again?
Yeah. Why is it that you didn't include in your retention agreement for AIS any risk disclosures concerning a multi-party representation?
Objection to form.
Well, I would say to that in the context of a multi-party state court action, that would be best practice, and it's a practice that I have used. But in the context of bankruptcy, a Chapter 11 bankruptcy, and the retention agreement was limited to representing them as claimants in a bankruptcy, the resolution or the conflicts or what have you were not going to arise because they were going to be treated however they were going to be treated under the plan of reorganization. And I had no role in what that was going to be, except to advocate for as large a pot as possible and to advocate that people be fairly and equitably compensated.
Has a conflict now arisen where you're in disagreement with the other 2 law firms that make up AIS?
Well,
in what path the bankruptcy should take?
Hold on one sec before you answer. I'll object. I would ask for clarification maybe. The word conflict can have legal significance, it can have just regular parlance. So to the extent you're willing to clarify that, that would be helpful.
I'm just using it the way it's written in the dictionary.
Okay, well, yeah, to me, it sort of feels like World War III, and it's unfortunate. But as you know, I think you know, lawyers can disagree with each other. Law firms break up all the time because of discord. The obligation of the lawyer in the law firm is to the client, fundamentally. So I don't see that there is a conflict here. It's unfortunate, but the way that the coalition and Eisenberg Rothweiler have gone about this balloting process, they have created and aggravated confusion because they have 3 law firms, 2 of which strongly object to the other's views in the case, and a 3rd one that hasn't been very clear about what his position is at all. And so I would just say I'm reminded of a very good book, Team of Rivals, where Abraham Lincoln put in his cabinet his political adversaries. And these cabinet members were also bitter adversaries of each other. And Lincoln thought that it was helpful to have conflicting views presented and that he could then decide. So in one sense, if it had been an honest communication coming from Eisenberg Rothweiler and the coalition, it might have been beneficial, but it wasn't. And so these clients received information that was unfortunately unclear. The fact that it was that we disagreed was not the problem. It was the way it was presented by the coalition.
You're taking a 40% contingency of the proceeds from the bankruptcy?
I'm sorry, would you say that again?
It's like, yes, your engagement, under your engagement, you're taking a 40% contingency of
me personally?
Yes. Well, strike that. Under Kosnoff's law's engagement associated with AIS, you're taking a 40% contingency on the payout from the
I'm
bankruptcy.
sorry, Mr. Schiavone, you froze. Under Kosnoff's law engagement associated with,
Under the retention agreement that Kosnoff law entered into, the AIS agreement, Kosnoff law is taking a 40% contingency on the payout to clients in the bankruptcy?
No, that's not accurate.
Okay, then tell us how it works.
The 3 law firms will receive, in most instances, a 40% contingency fee. Kosnoff law does not collect a 40% contingent fee. The 3 law firms do. And in some circumstances, my fee of that 40% is reduced substantially. So I have no idea what percentage fee I will ultimately receive, perhaps as little as 8%, 9%.
What is it reduced to get it to 8%?
What is it reduced to?
Yeah, well, what reduces it?
Well, there are law firms that referred cases to us who funded television advertising and took a percentage interest in the fee.
I'm sorry, you froze. Who funded the television ad?
Television, I'm sorry. Let's try again.
Go ahead.
There are other lawyers who advanced monies for television advertising, some of whom agreed to act as local counsel, or co-counsel should the bankruptcy fail and we need to file lawsuits in the various states. And they were entitled to a percentage of that 40% that would otherwise have gone to Eisenberg, Rothweiler, and AVA. And the percentage that went to those law firms, depending upon the level of their contribution, both financially and in terms of labor, would vary. It could be as little as 25% or as much as 40% of the fee collected. You follow me?
Yes, yes. So are there fee splitting agreements in place with other firms besides the three AIS disclosed firms?
I wouldn't say they're fee splitting. They are listed on the fee agreement with the client as being as sharing in whatever fee is ultimately collected.
And they're sharing because they lent money towards the advertising campaign?
Well, that's no small thing. They didn't lend, they paid money, and they wanted to be able to participate in this case. In some instances, they had their own client base, but they wanted to associate with our three law firms. There were a variety of motivations, but my contribution to the television advertising, I think, was about $400,000. But the total cost of getting our messaging out, I don't know what it was. You'd have to ask Andrew, but it was certainly more than the $400,000 I contributed.
Okay, so these other firms, they advance money towards the mass advertising campaign, and then they get back an interest in the upside in the claim, right?
Well, you could put it that way, but I saw it as somebody who we could rely on, not just to help us finance the cost of messaging, but also could help us litigate the cases. Or, for example, we had our first one was a law firm out of Dallas, very experienced trial lawyer down there. And we thought that this bankruptcy was going to be filed in Dallas. Turned out not to be the case, but he was ready, willing, and able to help us if it was filed in Dallas. We had law firms that I'd known for years, lawyers that are good lawyers that have worked in this area that I reached out to, and they came in. And so I don't know all of the law firms. Some of them I was familiar with, some of them I wasn't. Zuckerman Spader was, these were friends and also a really excellent DC law firm, and they were interested, and the lawyers there are wicked smart and know how to try cases. And so I invited them in, and it's sort of evolved. We were looking for money, but we were also looking for talent.
Is their interest in the claim for lending money towards the advertising or advancing money towards the advertising, is that memorialized in any kind of written document?
Well, I'm sure it was, whether it was by email between Andrew and them. I wasn't really involved in those negotiations. We generally, came up with some kind of formula that we thought might be fair, but it was dependent upon, the particular law firm and what we thought they would contribute. And they weren't, investing doesn't work, advance doesn't work. They were using their capital resources to help us pursue this case against the Boy Scouts of America. And that matters.
Well, What exactly has the Zuckerman firm done since it was filed?
What have they done?
Yeah.
Well, before they filed, they put together a 12 plaintiff complaint built around a legal theory of mine that had been circulating around in my brain for about 10 years.
Okay, I'm familiar with that. I know what you're talking about.
Okay, for the record, it was filed in federal court in DC, premised upon the idea that because BSA was incorporated in the district and had conducted business in the district, and that tortious acts were committed in the district, and because we had complete diversity, that the federal court had jurisdiction. And then when the district passed a window in May of 19, it was a go. So we filed it, and we thought it would get noticed by the insurers and by the debtor. But given this plan, apparently it was given very little shrift.
Can you give us the list of other firms that or companies that made investments in the advertising campaign?
Okay, I don't agree with the word investments. I don't know what the right word is. But yeah, they contributed money in the hopes that we would be successful and that they would recover the money that they had put into the effort along with a profit.
Okay. And what were those firms?
What were those firms?
Yeah, if you could give us a list of them.
No, I can't. I mean, I know some, but
give us the ones you remember.
Well, Mr. Schivoni, this was where it gets a little bit hard for me because some of these firms referred cases to us or participated in the cases that came in as a result of the television ad buys that their dollars had been used for. And then many of these firms started running their own ad campaigns and bringing in clients into their own firms. And I can't tell you how many or which, but I can give you the names of some that I know participated. I can't tell you how much.
Okay, just give us the ones that you remember that advanced money towards the advertising campaign in order to get a profit coming out of it.
Okay, well, do this for me. Give me the names of the law firms of the coalition. That'll help me.
Is it just coalition law firms?
No, but that's a start.
Well, there's Thornton and Andrews and
okay, no,
the Slater firm and Joe Rice's firm. I think maybe in there, maybe not.
No to all three.
Okay.
Let me throw out a couple names that I know for sure. Mark Byrne. Who's this lawyer? Something in Kinsman in Oklahoma, I think. I mean, now there's, I don't know how many law firms have signed up with the coalition. Let me see who else comes to mind. Napoli, no. The gentleman in Texas, McGartland, a friend of mine, Chad Bowers, another friend, Jeff Bowersox out of Portland. I mentioned Zuckerman Spader. They are essentially managing exclusively 1,700 clients that came in through their contribution. If you could throw out some names, I could tell you. Andrew is really the best source of this information. But I would say that we're probably talking on the order of 20 to 25 separate entities.
Calls would come into reciprocity. How would you figure out whether they were for, AIS or for somebody else, some other law firms for which Andrew was doing work?
Well, he's been doing this line of work in this way for some time, as you know. And, that's kind of a lot to keep track of, but he's kept track of it. And, I haven't gotten an accounting from him because there hasn't been a need for one. But someday at the end of this case, hopefully we'll have to do that, which is why I'm not being cagey with you when you ask me what I expect my fees to be in this case, because it's gotten diluted. And, I don't know. I'm dependent upon Andrew to be able to show us the numbers, because there are a lot of people that are going to be expecting to be compensated per our arrangements.
You signed some proofs of claim, am I right?
I believe I docu-signed proofs of claim, which is, I don't want to quibble, but I mean, no, I didn't put pen to paper. It was, they were sent to me. They were, I reviewed them. Many of them I had on my computer. I had read them. I had personally reviewed over 5,000 of them. So sometimes I'd see one and I go, I know this one. But yeah, they'd come across, and I would look for the relevant information. A lot of times, just because of the rush, details weren't placed in the correct box. They were in the narrative portion.
I'm just focused on the signature fixation right now. Like, how did you affix a DocuSign signature? How did you do that?
Well,
Hey, Tank, if I could, Dan Hogan here, I'd like to impose an objection just so I'm clear. As you know, the insurers have filed a motion to compel against Eisenberg Rothweiler in connection with getting discovery relative to client authorization to sign proof of claim forms. And I just wanted to assert and make you aware that that matter is before the court. And I wanted to impose that objection so that you don't delve too far down the rabbit hole here in terms of what the court's got on its plate to decide.
Okay, well, I'm just focusing on Mr. Kosnoff's signatures at this point. So we'll take it step by step. So how would you affix your how would you affix a DocuSign yourself?
Well, you've used DocuSign, I'm sure, and are familiar with it.
I got to tell you, when I started practicing law, we didn't even have computers. Okay, and I'm younger than you, so no, I've never used DocuSign. So tell me about it.
Yeah, well,
so how would you affix your DocuSign signature? How did you do that?
Well, I'm sort of with you on that, but I've had to become computer proficient to some degree. But yeah, I like the old-fashioned way where somebody's signature is on a piece of paper. But now just about everybody in the business world uses DocuSign. But to answer your question, I get a proof of claim form sent to me from either Rita or from Andrew's firm, and I scroll through it, for accuracy and completeness to the extent it could be completed. And then at the end, there's a little X and a little yellow tab, and you click on that, and it's got your virtual signature, and you click and it puts it in the signature box, and you have now signed it.
Okay. Was there a mechanism whereby the folks at Reciprocity could affix signatures themselves to the proofs of claim?
You're asking me, could that have happened?
Yeah. No,
Well-
did it happen? Let me ask you, first of all, did it happen?
I don't believe so. If they weren't a lawyer, then they shouldn't have been reviewing and signing or docu-signing proofs of claim. But I don't believe that happened. I think most of them, I think the bulk of them were done by Eisenberg Rothweiler, because, we 2 weeks out from November 16th, the bar date, we just said, we can't do this anymore. Let's just turn off the phones. So, but they kept coming in. So we started just referring them to other law firms because we couldn't keep up with what we had. So, so we tried that. It was really getting to be crunch time, and Rita was, she said, I need help. And so I told Stuart and Josh and Andrew, get her help. So they brought in all the lawyers in their law firm.
I can get off this thing if necessary at any time. Okay, sorry.
I'm sorry. Someone speaking?
Yeah, we're waiting for Mr. Schiavone to.
Mr. Scavoni's on the phone.
I gotta go. All right. Sorry about that.
Yeah.
It was my mother. I'm sorry.
Oh, good. You're a good boy. So, okay, where was I? Okay, so, so I said, look, Stuart's like, he's pulling what's left of his hair out, and he's, blah, blah. I said, how many lawyers do you have in this firm? I think you've got 13 and 3 or 4 associates. Get them in here, burn the midnight oil. Get them in here on Saturday and Sunday. We got to get this done. We need lawyers reviewing these and signing them, because otherwise men with valid claims are going to lose out forever.
Look, let me just say, who was actually talking to the claimants?
Talking to the claimants. Well, Andrew's staff, Rita's staff. I wouldn't say that I had a lot of telephone communication, but I would send an email occasionally to somebody saying, could you clear something up for me here? There's something about the summer there that I want to understand.
I'm sorry, excuse me. Can someone mute their phone? I hear water running or their screen.
Mr. Kosnoff, you signed a relatively large number of proofs of claim in one day. Have you read about that?
Yeah, and I was really interested. I spent, well, I guess compared to others, I didn't really sign that many. But, I think you've asserted that I signed, 400 within 2 weeks, something like that.
Well, maybe a day. Is it possible as a day?
No, but if it did, and I didn't know this until you brought your motion where you said Kosnoff, something wrong here, because Kosnoff signed proofs of claim in 5 different cities on the same day. And I thought, what is he talking about? I was in my little cubby office in my spare bedroom. And I think you were saying they were in Chicago and elsewhere and so forth. And, through your valiant gumshoe efforts, you were able to unmask what had happened. But this is what happened. One of the law firms that had referred cases to us, and I think they had contributed money and gotten an interest in the client cases that came in on their advertising dollar.
Someone put your mute on, please.
So I was somewhat acquainted with this firm based on what Andrew had told me, and that they had some cases with us, but they were out running ads and processing them through what you call an aggregator. And I don't remember which one. It might have been Veris. There are several involved in this case, I've learned from you. I get an email during these frantic days just prior to the expiration, asking me if on this one proof of claim, can they affix my signature? Now, I assumed, because it was a lawyer that was reviewing it and understood what the proof of claim form was. And I dashed.
I'm sorry, you froze again, sir. I'm sorry.
So,
I understood what the proof of.
proof of claim. He understood what that was. And
Madam Court Reporter, I don't think the screen freezes for anybody else when that happens to you, when that happens. I wonder if you need to reboot again.
I can certainly try. I don't have any messages coming across saying that I have a bad signal. But,
Is anyone else experiencing that?
Is it just me?
No, not having.
Probably just you, but listen, we've been going for an hour and 20 minutes. Maybe this would be a good time for a break. And Madam Court Reporter, maybe you can refresh your thing or whatever.
Can we have 5 more minutes to finish this answer?
yeah, let's try it. Okay, so where were we?
You were just about ready to tell me how you signed proofs of claim in 3 different states at the same day.
Faster than a speeding bullet. Yeah, no, this is not levity. This is serious. I received a request from this law firm or a representative of Veris or whoever the aggregator was. Could they affix my signature to a proof of claim, which I understood meant this was a co-counsel arrangement, and this was a lawyer. And I said yes. And then, much to my surprise, I learned from you months later that they had gone ahead and affixed my signature to many. I don't know exactly, but if any of those were not signed in Palm Springs, California, then they were not authorized by me to be signed by anybody else, anywhere else except one.
And what was that law firm that signed that used your signature?
Keller Linkner.
And did you do anything to suggest to them that, or to ask them to withdraw the proofs of claim or modify the signatures, or did you do anything to remediate it?
I object to the form.
To answer your question, no, I didn't.
Do you think there are other instances where signatures for either lawyers or claimants have been attached without the claimant's permission?
Without the claimant's permission?
Well, okay, that's fair enough. That's a good objection. Do you think there are other instances where a lawyer's signature was attached to a proof of claim without, by somebody other than the lawyer?
Object to form.
That's asking me to speculate. I just don't know. I would hope not. It's not the way I do business, and it's not the way the lawyers that I associate with, should be doing it. So I'm on your side on this one.
Did you ever see any kind of written protocol from Reciprocity on the procedures under which they go forward in preparing proofs of claim?
Well, again, I think that the bulk of the proofs of claim were prepared by Rita and her team. And they had their own team meetings that I wasn't involved in. sort of Rita's team with Andrew's team. And I know that went on regularly, but I didn't participate in those.
Hey, Tank, how about that break?
Oh, okay. Should we break and then continue tomorrow or the next day? Because it is almost 6. What do you think? I mean,
Well, look, you know, Mr. Kosnoff, I mean, you made yourself available today. Are you ready, willing, and able to continue today?
Yes.
okay, it's just I haven't been able to get it. Like, I have this prohibition on me looking at the documents. This is the problem I have.
Right. And my point is, that's not Dave Wilkes' imposition, nor is it Tim Kosnoff.
Okay. All right.
Let me finish. Just let me finish.
Yeah.
You and I don't think you and I have a dispute. I just need to put things on the record. I mean, he's been made available. Records were made available to you and others. We're ready to proceed. If others want to break now or stop asking questions now, you know, I'm reserving all rights that this is your opportunity.
Okay, let's get through another document first.
Well, let's take a break. Can we take a break?
break?
Let's take a break.
Yeah.
Let's
And the
make
court
sure.
reporter can refresh her connection.
Is 5 minutes okay?
Yeah, whatever you need, Tim.
Okay, thank you.
Okay, and we're going off the record 2:49. And we're back on the record at 2:59.
Yeah, so Mr. Schiavone, you asked me if I did anything after you brought to the court's attention that my signature appeared on proofs of claim that was affixed in multiple cities. I was upset, surprised, angry. I unloaded on Andrew because my only knowledge of Keller Lenkner was with Andrew. And I called up one of the lawyers there and I bit his head off. But I guess I don't know what else I could do. You had brought it to the attention of the court and the court would deal with it as she will. But that said, the proofs of claim themselves and the claimants behind those proofs of claim, I believe are probably legitimate claimants. And the fact that this law firm did this should in no way prejudice, you know, the men whose claims my signature was affixed without my authorization. So that's all I wanted to say about that.
Okay, well, that was very, you know, what it was. Mr. Kosnoff, is the bottom line is you didn't do anything to withdraw those proofs of claim or otherwise remediate the issue?
Sorry, I had a problem again. I'm sorry, Mr. Scribb. You have to say your question.
Okay. Thank you for discounting the transcript. I appreciate that.
Enter participant ID followed by pound.
I'm sorry.
Press pound to
Is anyone else having a hard time? Did that freeze for just me or?
No, but everybody appreciates that you're going to be discounting the transcript for us.
Well, somebody has to mute too, because somebody had a phone.
Yeah, somebody has to mute, so.
I'd like to pull up, Mr. Kosnoff, exhibit to the court reporter. We emailed this to you. It's marked DI 1285. Can you pull that up on the screen for us?
Yes, hi, this is the videographer. Actually, I have it here and I'll pull it up momentarily.
Oh, terrific. Now, Mr. Kosnoff, this is the only copy I had handy. It's a pleading, a notice of filing exhibit. But what I really want to go to is the exhibit that's attached to it. So if we could just go down to Exhibit 1. And Mr. Kosnoff, can you tell us what Exhibit 1 is?
Can you make it bigger? Yeah, I think, okay. Yeah, this is the infamous Kosnoff oops reply all email that you've made great hay out of. Go ahead.
Right. So can you, is this an email that you authored?
Yes.
Okay. And you sent it to Mr. Smola?
It was intended to go to Ken, Josh, Stuart, Andrew, Carl Kravitz, and Andrew Goldfarb, I believe. But that's not where it went.
Okay, so but you did send it. You sent this email. By the way, court reporter, what is the exhibit number for this?
That would be the technical person. I'm taking the record. I'm not doing exhibits today.
Okay.
If we add this to the marked exhibits, it'll be 29.
Okay, so on Exhibit 29 is a email that you issued. Just go to the top again. You issued this on June 28th, 2020, to the recipients listed on the exhibit, right?
Well, that's where it went to. I would say it was more of a rant, but yeah, it is an email form.
Okay. And I just want to sort of walk through some of the things in here for you. It's
Sure.
like in the first sentence, you have yes, but no more. What were you reacting to there in saying yes, but no more?
That we, our firms had been marginalized by the TCC. They were totally under the influence of Jim Stang. Jim Stang was, I'd seen it before. He could be very, how do I put it? He talks to survivors and he makes them feel important, and particularly when they've just selected him as committee counsel. And so he marginalized not just me, Andrew, Eisenberg, Rothweiler, and the Zuckerman firm. We had one representative on the committee. That's the way it was formed. And some of these people on here had one client. We had 5,000, 7,000, 10,000. And suggestions that we made were not appreciated. And ultimately, this relates back to our belief, our group's belief, that it wasn't going to be a sleigh ride litigating against you or any of the other insurance carriers, that was going to be a tough, long, hard fight. And that if we were going to get compensation for our clients, we had to turn our first attention to the relationship between BSA National and the local consuls, which I had spent a lot of time studying. And we had done research, and we believed that there were legal theories that could have resulted in the consolidation of the assets of the consuls into the debtor's estate. It was reported by the Wall Street Journal that 80% of all the assets of scouting reside in the local consuls. So when they rejected it and said, no, we're just going to go forward without doing that because we don't think that's the way to go.
Mr. Stang rejected going after the local councils?
Well, in what I described, substantive consolidation, he didn't believe in the legal theory, and I think he gave it short shrift. When we gave him a research memo, he sort of backed off and said, well, maybe, but if anybody's going to do it, we have good litigators at Pachalski Stang, we'll do it. So, okay, I understand now. Jim Stang is, he's a good bankruptcy lawyer, but he's not a litigator. And I didn't see anybody on his team, no disrespect, but this was a big one. So we proposed that they hire litigation counsel, and they rejected that idea. So I think this email about the time reflected my frustration and anger that we've been marginalized. I said they are wasting their time talking to the TCC regarding, well, I refer to Mike Andalina and the three amigos, which is how I characterized or called the three mediators. And when I said we control 80% of the claims, i.e. our coalition controls the case, coalition, there was no big C coalition. This was our group of attorneys plus Ann Andrews and who else had a member on the TCC, Slater Shulman. And they agreed with me. They agreed with us. This is what we have to do. And it's pointless sticking around here. So when I said, here's the message, we control 80% of the claims, our coalition controls the case, that was a statement, not that I wanted to go and round case. It was a statement that the TCC was going to have to take us seriously, that they couldn't marginalize us, that they would never be able to get to country if they didn't work with us. So that's what that meant.
I'm sorry, you're cutting out. Is that just me? Because if it's just me, then there's a problem.
Yes, we've established that part.
Well, that was me.
Well, no, I'm sorry. I'm taking the record here and I need to get every word. And if it's cutting out, I'm sorry if it's on my end, but I don't see anything on my computer that's saying I'm having a bad signal. Is anyone else?
Mine was glitchy there too.
Okay, thank you.
Mine too.
Okay, thank you. Could you please say if it didn't, they would never be able to give if they didn't work with it?
Yeah, that notwithstanding the fact that we had one or two members on the committee, we controlled a lot of votes. And, we deserved respect because to get to consensual plan, you need voting support. And so that sentence, Mr. Schiavone, we control 80% of the claims, i.e. our coalition controls the case. We just wanted to be recognized. We wanted to be taken seriously, and we weren't. So at this point,
I hadn't got to that. I was just focused on the yes, but no more part. It's like yes, but no more was all about the fact that he wouldn't, Mr. Stang wouldn't pursue substantive consolidation.
Yes.
Okay. Well, how is it, if that's really what it was, how is it that when the coalition was formed, you didn't file the substantial contribution consolidation motion?
Yeah, and that's why I left the coalition, because that was the plan. Only it wasn't the plan. But by the time I discovered that, you had all these mass tort world dwellers who had joined this thing of the coalition. And I'm like, who are these people? And, I was bamboozled, to use your word. Maybe I shouldn't have been. I mean, I was naive, but I came from a different world.
Mr. Kosnoff, are you really asserting you're naive?
Well, when it comes to the world of mass tort lawyers and how they operate, I've learned a lot. But at the time, not so much.
But here you are, a novice to the mass tort world, in the second sentence saying, we need to control our power. And was the power the voting block you were focused on?
Yes, our views could only be enforced through our voting block.
And had you formed a voting block at that point?
There was nothing to form a voting block around. I wanted to bring in somebody from the outside who would pursue what Jim Stang refused to do. And, you know, that was an exercise of power if we could do it.
Let me ask you about this voting block thing, whether there was no voting block at this point. It's like, had you met with any people from Wall Street at this point?
No. That came maybe late July, August. What's the date of this? About a month later. And we were talking to a lawyer who had actually pitched the committee way back in February. And the more I learned about him, the less I liked him and the less I thought he was suitable. And Anne would say, she liked to say, well, I've got a lot more tricks in my trick bag. Let me reach into my bag and see what else I can pull out. Eventually she pulled out Brown Rudnick, and I knew nothing about them, but they were supposed to be dynamite litigation counsel. So that's where we were. I was floundering, frankly. I was angry at Stang. I was angry that the members of the TCC, you know, I mean, they knew nothing about this world, and yet they acted like they were the board of directors, and Stang treated them like that. And, you know, it was disrespectful, it was rude, but, you know, generally an official committee is made up of experienced professionals who know something about the Chapter 11 that they're involved in. And as much as I respect them, being a survivor of child sexual abuse doesn't qualify you to make some of the decisions or to even understand the context in which they're operating. Well, that was not, you know.
Did you suggest a moment?
Pardon me, Mr. Schiavone. It's Cameron Moxley of Brown Rudnick on behalf of the coalition. Let me just note again that the coalition has not waived privilege, and to the extent the witness is discussing privileged communications amongst counsel during the, I believe he said the late July, early August time period, we have not, the coalition has not waived the privilege and asked the witness not to reveal privileged information. Thank you.
Okay, well, I don't think we're there yet. So we're still in June, July, Mr. Schiavone. So go ahead. What's your next question?
So it's this, like Mr. Stang was treating the members of the official committee as if they were a board of directors. Was that your assertion?
Yeah, that's what he was doing.
And you thought that was disrespectful to the lawyers who representing other committee members?
No, I thought that I was disrespectful to their authority. They had been appointed by the United States trustee, and I've worked with sexual abuse survivor committees, but I'd never been in one where I had so many clients and yet had so little influence on the official committee.
I see, but does it matter who it's like, is that how the committee members are supposed to be appointed proportionately by the lawyers who represent them?
Well, there's no supposed to it. Every trustee has his own ideas, and I suspect that our U.S. trustee was aware of how many clients we had and wanted to put together a committee that wouldn't be dominated by the law firms that represented the vast majority of claimants in the case. That's a judgment call by the U.S. trustee. Sometimes it makes sense. Other times it can be disastrous.
But you certainly didn't have any questions about the fitness of the individuals who were selected to serve on the committee, right?
No, these were honest, men, some of them, professionals, but they didn't come from the legal world. There was a retired lawyer that was on the committee, but he had no relevant experience in this. And so they're being asked to make, I guess, decisions based upon Mr. Stang's recommendation about very important strategic and tactical decisions that could have profound effects on the outcome of the case. That was my concern.
I don't want to use names here, so please don't respond with any kind of name, but didn't some of the committee members actually have experience with litigating sexual abuse claims?
The committee members?
Yeah. Hadn't they previously litigated sexual abuse claims?
No, there were no child sexual abuse civil litigators that were members of the TCC. They may
No, fair enough. I'm not asserting that there were any members that were lawyers, but I'm saying as defendants, hadn't some, or strike that, as plaintiffs, hadn't some of them actually been through the legal process before?
Yeah, and there were some good ones.
Okay. So are these the people you were referring to in your email as dimwits, the committee members?
No, I think I was referring to Stang and.
Well, that can't be, because Mr. Stang's name is before dimwits. For Stang and the dimwits. So it can't be that you were referring to Stang as the dimwit.
Right. Well, I guess the dimwits would include the council members that were supporting him and those lawyers who were also listening to Mr. Stang. I don't know that he had support, but I think generally there was sort of a feeling of let's not do anything, let's go into mediation and see what happens. And I thought that was a bad idea.
Okay. But at least some of the dimwits were, in your view, the committee members.
Yeah, and that's not fair. And I apologize to them. These are men who have devoted an enormous amount of time and energy to this case and learned a lot. And there's nobody in this case that hasn't made mistakes. I've certainly made mine, but now they got it right. And it was a mistake that they signed that RSA, but now they're opposing this plan, and I'm on board with that. And so, we're copacetic again.
Well, how could it be that you were so antagonistic to Mr. Stang at this point in time, and then now you're allied with him? How did that come to pass?
Oh, have you ever kissed and made up? Just shook hands and said, okay, I said this, I'm sorry. But in this case, Mr. Stang never should have gotten this email. It was obviously a mistake. And, there are ethical rules about that. But he goes further and he puts it into the public record of this case in a fit of pique against me. So, I don't know if those hard feelings are ever going to be resolved, but I'm staying focused on this case and hoping that I can be productive to getting it to a place where a legal, confirmable, fair plan can be confirmed. And today, I think we're further away from that goal than ever.
Reconcile your statements about wanting every claimant to be individually balloted associated with AIS with your statement in this email that, quote, we control 80% of the claims.
Well, okay. When I talk to clients individually or collectively and explain my views, they tend to agree with me. I don't want them to vote because I tell them. I want them to vote the way I recommend because I make sense. So that's how I would reconcile it. I have enough belief in myself and in my ability to communicate with claimants like this. You know, maybe not to a group of bond holders or something like this, but I've been talking to abuse survivors for 25 years. And we're now in this environment that personally I believe is wrong. I don't think that bankruptcy should even allow sexual abuse cases to be brought. It's re-victimizing, and this case has devolved into something that I'm sure many of them now regret having ever come forward and opened up these old wounds. But they did so not because of me, but because of the Boy Scouts of America, who made the decision to try and discharge the claims of all these men in bankruptcy, including men from states that you say are closed or non-window or what have you. Well, that's not what the Boy Scouts of America's advertising and messaging said. It said, come forward and be compensated fairly. And many of these men came forward not because of AIS television ads, but because the BSA's ads came forward and said that. And they believed them. And
Mr. Kosnoff, I mean, please, didn't you intentionally run ads to try to bring in claimants from states that had statutes of limitations in place? I mean, don't you say that in your 2019 statement itself?
Well, that's correct.
I'll object to the form. Go ahead.
The Boy Scouts invited them. I simply echoed the message that the Boy Scouts of America said. You know, Mr. Schiavone, the Boy Scouts of America don't want to discharge just of men in window states or open states. They want a national discharge. And these are men who were abused in states where the window may well open. 5 of them have just in the last year. There's a trend line going on here.
Am I correct that one of the things you did in trying to generate proofs of claim was you went back and claimants who you had previously declined to take on as clients because they were in states with unfavorable statute of limitations, you took those on and submitted proofs of claim for them?
Hang on a second, Mr. Kosnoff. First of all, Mr. Kosnoff had not completed his last answer. Now, Mr. Schiavone, you're well within your rights to cut him off, but understand there is more testimony there that now you will not hear. As for the pending question, I object to the form.
Right again, Mr. Schiavone.
Will you just read the question, please? Well, I'll hold it. Forget it. I don't want to go to the reporter. Let me do it. It's Mr. Kosnoff. Isn't one of the things you did was that you went back to claimants who you had declined to take on as clients because they resided in states with unfavorable statute of limitations, and you contacted those clients and submitted their claims as proofs of claim in this case?
Correct. New York, New Jersey, Vermont, North Carolina, Arkansas, California, Arizona, Hawaii, Montana.
No, I'm not. Okay, I'm not talking about. Go ahead.
Let me finish. All those states I just rattled off, they have opened just since this bankruptcy was filed. And you know that because your client spent millions of dollars lobbying to try and prevent the passage of these window statutes. That's documented. It's in Chubb's annual report. So did the Boy Scouts of America. Caught the attention of the House Oversight Committee? Why are you spending millions of dollars trying to defeat laws that would allow victims access to the courts? So if you don't understand, if you don't really know this history, I'll be happy to talk to you about it. But I'm always left guessing how much you actually know and how much of this is play acting.
No, I was really referring to your 2019 statement, where you state that the three firms would oppose any settlement that distributes money to clients based on the accident of geography or the caprice of insurance coverage periods. That is, if a client had been abused in a non-window state, the claim would not be reduced on statute of limitations grounds. Are those words you wrote, sir?
Yes, and I still believe them.
Okay, so I'm just asking you, is one of the things you did was that you tried to find and solicited claimants intentionally in non-window states and submitted their proofs of claim.
Object to form?
I didn't know that they were going to be, well, the states I rattled off were non-window. Now they're window. Okay, wait till next year. Iowa, Michigan. Okay, so let me finish, Mr. Schiavone, let me finish, okay? So we can have a long discussion about statute of limitations. You treat it like it's a binary question, on and off. It's not. It's way more complicated than that. There's politics involved here. You know that. This case alone is probably going to trigger the passage of more windows in the next legislative session. I mean, I've got my ears to the ground. So yeah, I believe people should come forward in response, especially to the message of the Boy Scouts of America. Come forward and be fairly compensated. Didn't say if you were abused in New York or California or any of these states. It said, no, come forward and get fair compensation. Their words, not mine. Going into bankruptcy, their choice, not mine.
Let's just go back to the memo where it's like the email you wrote to Mr. Stolta Smola. Okay, that's exhibit 29, I believe, right? If I want to draw your attention to a sentence in the middle of the thing that's the one about that starts, we are not going to do. Do you see that?
Help grease the gears for staying.
Right. So it says, we are not going to do anything to help grease the gears for Stang and the dimwits, including speeding up the insurance analysis. Have I read that right?
Yes.
Okay. And is one of the things that you were trying to convey there is that the coalition of firms that at that point you were leading was going to try to slow down the mediation or not cooperate with it?
Again, Cameron Moxley of Brown Redneck on behalf of the coalition. The same caution, Mr. Kosnoff, not to reveal privileged information about the coalition from that July 18th period forward. Thank you.
Yeah, I think you're right, Mr. Moxley. I think this is drifting into that area. I mean, I can tell you my own thoughts about this sentence, but I guess the point here is I thought that Mr. Stang was too friendly with Mr. Andalina. I didn't like the way that he was using the softball approach. Mr. Andalina was asking for consent for us to provide all of our client information to him so that he could turn it over to the insurance carriers. And I thought that was inappropriate, premature, and I didn't want to play into that, what I perceived to be a too friendly, footsie relationship going on between Mr. Andalina and Mr. Stang.
You actually thought, I just want to get this, I just in case I misheard it, you thought Mr. Stang was being too friendly to Mr. Andalina.
Yeah, Mr. Andalina had, he had ideas about how the way he wanted to run this case. And I think that I believe Mr. Stang was being too passive.
And one of the things that you thought was really wrong was the notion that you should share with the insurance companies the names of the claimants for whom they were being asked to pay money.
Well, no, we both know that we were still at this point in the, during the claims bar period. Here we are in July, August. So we don't even know what the totality of claims are, number one. Number two is the insurance companies had much of our information, or so I was told, because
The 82,000 claimants, really?
Mr. Scavone, let me finish, okay?
Okay.
So no, nobody knew the 82,500 claimants because it wasn't November 16th yet. I had an idea of how many we had in the spring of 2019, in August of 2019, in September, October, when we met with the BSA in Los Angeles, and again in New York City in November. I believe you were there too. I seem to remember you. And so we had been providing BSA general counsel with spreadsheets for months of our clients, of relevant information, mostly because we had hundreds of perpetrator names that did not appear in the perversion files or had ever been publicly identified. And the Boy
I'm sorry,
Scout
you froze again. I'm sorry. That did not appear in the perversion files.
in the perversion files or in available public information on the internet, these were hidden predators. And the Boy Scouts had earlier said that their policy was that they would report all instances of sexual abuse to the police, to the local authorities. So we're sitting on all this information about all these hidden predators. And in one of our meetings with our team meetings, I said, look, we can't sit on this information. We're compromised by it. Children may be at risk. We need to send this to the Boy Scouts of America, and they need to notify law enforcement in all these communities. We didn't have the ability to communicate or make reports to 1,500 counties and municipalities or whatever it is in the United States. The Boy Scouts should be doing that. They said they were going to do it, and we said, fine, here. So we kept providing additional information and additional information. So
to who? The Boy Scouts?
To the Boy Scouts, to general counsel. So I guess I assumed that you were not being sincere because I couldn't imagine that your insured was not sharing that information with you. I mean, maybe they were and you're not being candid, or maybe this is just taking you by surprise. But when you stand up in court and say, Mr. Kosnoff, they started out with 300 cases and now there's all these tens of thousands. There has to be something wrong here. I mean, I think, wow, did Mr. McGowan not share those spreadsheets with his insurers, with the dates, locations, places, and so forth? So I had no reason to want to make your job any easier when I'd already tried with the Boy Scouts of America. This information was available. You had a head start. You could have started tracking down this information, verifying it. So I don't know. I guess that's between you and your insured.
Well, are you finished?
No.
Yeah.
So anyways, I just want to say we continued that process for probably 3 or 4 months and continued doing it even after they filed. So I don't know what more you expected us to do.
Yeah, I was just referring to the sentence where you say, we're not going to do anything to help greet the skids for Stang and the dimwits, including speeding up the insurance analysis. Ken, that's playing into the Andolino Stang program. Message is, we're not playing.
Right.
Those are the sentences I was referring to. It's like you were slowing down the process, weren't you?
I
The same-
wanted,
I'm sorry.
Pardon me,
I don't know what
Pardon
it
me.
is with your connection, but you cut out.
pardon me, the same privilege caution, Mr. Kosnoff.
He's waived the privilege.
I wanted substantive consolidation of the consul assets into the debtor's estate. And frankly, if that had actually been done, the debtor would be in a much better place today than they are.
Okay, let me bring you to the sentence down below. It says either that or go. You see that sentence? It says either that or go sell 15 to 30 M of our case to a mother funder. And to let it, and then I'm not going to read the rest. It's too offensive. Evan, did I read the first part of the sentence correct?
Yes, you did.
Okay. What is a mother funder?
That was a term that I forget who used it, but it refers to the hedge fund lenders who loan to mass tort law firms to finance their television advertising and the build out of their aggregator system. I don't know, but I liked it. And I agree it's offensive and I apologize. It was a private communication and I'm sure you've said things in private that you're not entirely proud of, but I didn't put this in the public record. Mr. Stang did.
Let me just finish this. So as of this date of this memo, June of 2020, you knew about hedge funds lending money to the Boy Scouts already, right?
Yes, Ann Andrews said, we need to hire a litigator. And I said, well, who? And what's that going to cost? And she said, there's money available on the street. And I later learned what she was talking about. And these are, I don't know, what are they, private equity or whatever that lend to mass tort lawyers. And this was her proposal, that this is how we would finance hiring a top flight litigation law firm to pursue substantial contribution.
And is the way this
Pardon me, move to strike is non-responsive.
Is the way this works with mother funders, or strike that, is the way this works with the hedge funds on Wall Street is that they invest money in the case by buying part of the claims?
Objective form. You can answer.
I'm no expert in this, except, I know what I encountered in this case. But no, these were lenders or hedge funds, unregulated. They're not a bank, and they'll make non-recourse loans to mass tort law firms and other entities. And they are typically, I don't know, but in this case, pretty high interest rates. And the terms were harsh. And you have to understand something about me. I've never borrowed. I don't believe in leverage. And this just was not in my DNA.
You're not talking about borrowing here. I noticed what you were saying is go sell. Didn't you use the word sell? You didn't use the word borrow, right? You used the word sell.
Yeah, that was inartful. They weren't getting any interest except that the loan would be securitized by our interests in the fees in this case.
Well, that's curious. It doesn't say that.
Just a moment. Okay.
Sorry, go ahead.
Either that or we go and borrow $15 to $30 million of our case to a mother funder. That's what I intended. I may not have used the word bought, but we weren't selling anything, but it certainly felt like that when to order to properly manage this case, we were going to have to go on, we were going to have to pledge our interests in the fees in this case, just to hire a law firm to do what I believed the TCC should have been doing.
Isn't that though what it's, you didn't use the word borrow, you used the word, and you didn't use the word lend, you used the word sell an interest, right? I mean, that's what it's like, is what they were taking was a percentage of the fee that could change depending upon what the outcome of the case was?
Well, you're distorting it. I've now told you twice, that's not what happened. That's not what this is. You can hammer on that. These are documents. You probably already have them. These are,
Contemporaneous documents. Contemporaneous with the events, right?
Well, no, but I assume you've dug up these security documents that are available. They're UCC filings. I can't imagine you haven't gone and pulled those. So you know what they are better than I do. So don't play semantic games with me, please.
When did you meet the hedge fund lenders?
I never met them.
Okay, did you ever speak to any of them?
Most of this was handled through we talked about him earlier, Steinfeld from Minnesota, Ask law firm.
So the same caution, Mr. Kosnoff, please, not sort of privileged information.
Okay, so yeah, I mean, I think that's about as far as I can go. And I'd like to talk about that with my lawyer because, by this point, there were a lot of things that hadn't been finalized, and I can't recall. But as I testified earlier, I never signed any loan documents and withdrew from the coalition shortly thereafter.
Why didn't you go forward with the transaction with Caterpillar?
Well, as I explained earlier, once I got into this, there were all these names and faces and people that were showing up as new members recruited by Ann and Adam Slater to the coalition. And I began to realize that I did not share the same interests and goals that they did.
Move to strike.
You mentioned that you had a lot of, you've done some settlements in the sexual abuse field. Is that right?
Yes.
Is one of the things that defendants like the Boy Scouts that they're concerned about in connection with settling a case is the possibility of punitive damages against them?
You'd have to ask them, but there's actually not that many states where punitive damages are a significant factor for a variety of reasons. Punitive damages are basically on their way out. The Supreme Court doesn't like them, other courts. So I don't think they generally analyze cases on the basis of punitive damages.
You've raised punitive damages in settlement negotiations with the Boy Scouts, haven't you?
Yes.
And another concern that they have is the publicity surrounding the cases that you might bring. Is that a concern
for me?
To drive settlements?
Are you asking me whether it's a concern for me or a concern for them?
No. Is it in negotiating settlements with the Boy Scouts? Did you find that that the threat of publicity about the case was something that drove settlements?
I don't recall ever saying that in the context of a mediation. The Boy Scouts are well aware of the damage to their image and reputation and have been for a long time. So I certainly didn't need to spell that out to them. But if I was in a state where I could plead punitive damages. I did so. And those were for reasons aside from the pressure of a large punitive damages component could cause, but it expanded the realm of admissibility and discoverability, which you don't get if you don't plead punitive damages. So you may not get an instruction on punitive damages. It may eventually get struck, but I don't know if you know the criteria for awarding punitive damages, pattern and practice. You can get evidence through punitive damages that you can't get where you don't have punitive damages. So for tactical reasons, it is important to use punitive damages when you can, because you can learn a lot more about what the defendant has done, not just in this case, but in previous cases. And I think they're more concerned about their secrets spilling out than they are about the cost of an actual punitive damages judgment.
Well, is that it? Is that sometimes the threat of a punitive damage award, it has some impact on what the settlement amount is?
Oh, I don't know. I mean, the Boy Scouts of America really made, to me, just a colossal mistake in not settling that Oregon case, which had punitive damages. And they got, I don't know, I think the compensatories were 5 or 6 and the rest were punitives. And that made headlines. And, you know, it was a case that they could and should have resolved at the time and didn't. But once they did that, and then the rest of the perversion files got out into the public, they opened up the floodgates. I mean, that was a pivotal moment in the story of the Boy Scouts of America and their legal woes.
By the way, you gave those IV files to the LA Times?
The ones I had, yes.
Okay. Were they under a confidentiality order?
No, sir.
Okay. With regard to the issues about press coverage, did you ever find that using press coverage helped you drive a larger settlement amount against the Boy Scouts?
I can't say. It's true that I think sunlight is the best disinfectant for this kind of pus. And so I would file a lawsuit, and if my client was willing, we would hold a press event and he would talk about what happened to him and whether that caused the Boy Scouts of America to settle or not. Typically, those press events happen at the outset of a case. It's really the only opportunity that the plaintiff has a chance to speak to the public. And then that's it. If there's a verdict, then maybe there's some more reporting, but generally at the opening, that's the survivor's opportunity to speak his truth, because he's probably not gonna get a chance to do that inside a courtroom.
Have you issued public statements about the Boy Scouts' current operations, characterizing it as a rape factory?
That doesn't sound familiar, but it does sound like me. Go ahead.
Okay. Well, have you called the Boy Scouts' current operations a rape factory?
I don't recall. I think I've referred to them as the largest pedophile ring on earth. And I think I've also referred to them as pedophiles are us.
Okay. And that's when you referred to them as that, you mean their current operations, or they're the largest pedophile ring. Is that right?
Listen, this is what I know. There were 84,000 men who came forward and filed proofs of claim in this case. 84,000. Do you know how many people can sit in the Dallas Cowboy Stadium? 70,000.
Object is non-responsive. I'm just asking you whether you said this. Have you said?
Yeah,
that-
I've been saying for a long time that this is an organization that is unsafe. It is a high-risk organization, and it has to do with the way it's structured and managed. And I have seen nothing that they have done. And their own director, who resigned after 10 years of trying to get them to implement reforms, said that this continues to be a high-risk organization, unsafe. He said that a month ago.
Is it fair to say that you don't, like, you really don't have an interest in seeing the Boy Scouts being reorganized?
That is not really up to me.
Well, I know it's not up to you. It's up to a federal judge, but is it fair to say that you don't want the Boy Scouts to be reorganized?
I would say that I speak for a large percentage of the claimants in this case that actually believe the only way to make kids safe is to eliminate the Boy Scouts of America. This judge seems to be determined to put this debtor back into business. The coalition BSA plan has placed no meaningful safeguards to prevent the future abuse of children. Mr. Schiavone, I have a client, Mr. Schiavone, I have a client who's 93 and I have a client who's 7 years old and everything in between. I haven't seen anything in what has come into us that suggests to me that any reforms, the Boy Scouts have been talking about reforms since the 1980s. And all that's done is, well, it's increased awareness. And so more victims disclose and come forward. But the average age of a survivor, when a male survivor, when they disclose is age 52. So all the 10-year-olds, 15-year-olds, 20-year-olds, we're gonna have to wait another 35, 40 years before they finally disclose. And then we'll know whether or not the Boy Scouts today are any better than they were 50 years ago.
Mr. Kosnoff, my question is a simple yes, no. Is it fair to say that you don't want the Boy Scouts to be reorganized?
No, I'd say I don't care.
Okay. Have your actions been driven, Mr. Kosnoff, by a desire to see the Boy Scouts not reorganized?
No, they've been driven by a desire to see my clients treated fairly and compassionately by an organization that committed the most unspeakable horrors on these men.
And you would be, even though you've made statements that the present day operations of the Boy Scouts constitutes the largest pedophile ring in the country, you would be okay if they are reorganized?
Like I said, Mr. Schiavone, I try and focus on things that are within my control or power, and that's not one of them. But I will say that I believe that the Boy Scouts of America have been on the road to perdition for 70 years, and they have arrived. I don't see a future for the Boy Scouts of America. That's not a statement of preference. It's a statement of observation and judgment based upon my experience.
It's like, okay, you had, there are three lawyers working, three law firms working for, well, I don't want to say two lawyers and one law firm working for AIS clients.
No.
No, I got that wrong. Are there more?
There's no AIS. There are three law firms.
Well, maybe we should focus on that. The retention agreements are with AIS, aren't they?
No.
Isn't the contingency arrangement with AIS?
No, it's with the firms that are identified in the retention agreement.
Well, but they're not on the letterhead. AIS is.
Mr. Scavone, you know, I wanted to accommodate you as best I could, but I am getting worn down by your questioning, repetitive questioning. The letterhead is the letterhead. Wave it around, say what you will, but we filed a 2019 AIS isn't a thing. It's a URL. It's a, I don't know what it is.
Well,
But
okay.
it's not a thing.
Would you agree with me that anybody who thought they committed to give a 40% contingency to AIS and who discovers that AIS doesn't really exist and isn't a real entity, that they shouldn't really have to pay a contingency to anybody?
Objection.
Objection.
I don't understand the question, frankly.
Hey, Ted,
Really?
We've been going for another hour. This is a good time to take a break.
What is it? Let me just, it's like if the AIS engagement
Can you
letter.
Hey, Ted, can you answer me?
Now, just a few more minutes here.
All right.
The AIS engagement letter says that you'll only represent them in the bankruptcy. Am I right?
The initial one was, it's been expanded now to cover some other states.
Well, that's the one that must be not filed with the court. I mean, there's something for Hawaii you referred to, right? It's like, but the one that's filed with the court for your 17,000 claimants, that's the one that says the work is only in the bankruptcy, right?
Check the form.
Yeah, so what I'm telling you is we agreed to represent the same clients in causes of action brought against local councils in the states I mentioned previously.
When will you be giving us those engagement letters?
I don't.
Objection.
I have them. You can ask Andrew. I don't, maybe his lawyer can get them for you. I don't know.
If some of the AIS lawyers are advocating against the plan and some are advocating for it, what value do the AIS lawyers collectively provide to justify them getting almost half the recovery?
Check the form.
Objection.
Yeah,
It's time to take a break. It's time to take a break.
Okay, why don't we, it's like, so we made the point, it's like, is there an answer, Mr. Kosnoff, to that question?
This is the last, give this answer and then we'll take a break.
It's you're rhetorical and I don't know how to answer rhetorical questions.
Really?
Let's take a break.
You haven't been shot. It's like, why don't you explain?
Off the record,
Explain
please.
to us what value is being delivered to the clients for losing half their interest in the claim.
Don't answer the question. I asked to go off the record, and so we're going off the record, please.
No, there's a question pending.
No, there wasn't.
Mr. Kosnoff?
I asked to go off the record. And
what value is being given to your clients for losing almost half their claim?
Okay, look, here's what's going to happen.
Objection.
Okay, Mr. Hogan objected. I asked to go off the record. Mr. Scavone refused. I asked to take a break, which we've been going over an hour.
Is this what it's really about, Mr. Kosnoff? Can't you explain?
Okay.
Explain to your clients, just like, what is it? It's being done to it's like all you're doing is representing them in the bankruptcy. They're losing 40% of their claim. Half the AIS lawyers are saying do one thing, half are saying do the other. What value?
Okay.
It's like all the statements you've made, what value is being delivered to them to lose half their claim?
Okay, so that's the third time we've heard this speech. We're either going to stop the deposition now because of your conduct, or you're going to do us the courtesy of taking a break. One or
Mr.
the other.
Kosnoff, is this how you want this to end? You don't want to be heard on this?
I'm going to
Objection to this ending right now.
Yeah, I don't want it to end either. I don't want it to end either. But
We're going to the court. We're going to the court. We're going
Sorry,
to the
wait a second, one at a time, please. I don't know.
I'm asking for the courtesy to take a short.
No, we're going to the court at this point on the privilege issues. It's like they're too overwhelming at this point. We're going to go to the court on the privilege issues.
All right, so that question is withdrawn. So what do you want to?
No, it's not withdrawn. It's not withdrawn.
Okay,
It's
fine.
like they're totally fair questions.
Fine,
Mr. Kosnoff won't answer it.
fine. What do you want to continue with the deposition this evening? If so, we need to take a break and he will answer that question. Or you can discontinue it. That's your choice.
No, it's like when there's a pending question, you don't take a break. The witness answers it.
Well,
Let me just
This is
note
the
an
last
objection to the
one. This is the
question.
last one before the break.
Let me just note my objection to the question. We're going to get an answer.
He wants to know what,
I
he wants
guess,
to know what value you
I
have.
guess when this case is over and they look at the value I have, along with Andrew's firm and Eisenberg Rothweiler, delivered value and given them something back more than just financial, their self-respect, the healing of being represented by an advocate, and by holding the Boy Scouts of America accountable, we'll know then what the value of our representation was. Okay?
Okay. Let's take a short break.
Going off the record at
What?
4:04.
No, hold on. It's like, look, basic, my questioning is going to be suspended pending application to the court.
Okay.
If others want to continue, that's fine.
Mr. Kosnoff is ready and willing to answer Mr. Schivoni's questions. He chooses not to do that. That's fine. Does anybody else want to ask questions this evening? If so, say so, and then we can. But we're gonna take a break, a short break. I'm talking 5-10 minutes.
Yeah, this is Joe Gray. I would like to ask a few questions. I'll be short, and I actually mean it.
And I have a series of questions I'm going to be asking as well. I intend to ask. So,
Okay. All right. So can we come back in 5-10 minutes?
10 minutes?
Please, I need a break.
Yeah, let's make it
You're the
10
one I
minutes.
was thinking of. You're the one I was thinking of, Madam Court Reporter. So 10 minutes.
Okay, so now we're off the video record at 4:05. We're back on the record at 4:16.
Mr. Kosnoff, my name is Daniel Hogan. I represent Eisenberg Rothweiler. How you doing so far today?
I'm getting a little tired, frankly, but nice to meet you, Mr. Hogan.
Let me ask you, you testified about these emails that you sent to AIS clients and had communications with them about waiving the attorney-client privilege. You familiar with that? Those emails that we discussed earlier today. I know it's been a long day.
Right, they emailed me. They said something I thought was important. I asked them if they would waive their attorney-client so I could bring their communication to the attention of the court.
And to that end, did you ask them whether they waived any other privileges?
All I said was, I'm only asking them to waive with respect to this one specific email exchange.
And it was only as to the attorney-client privilege, is that correct?
I asked them if they would waive or give me permission.
To waive the attorney-client privilege, that's what I'm asking.
To waive whatever rights they may have had to allow me to use the communication.
Did you ask them about waiving any work product privileges or work product doctrine privileges or anything along those lines, if you recall?
Work product right of a client who's emailing me? I don't understand.
Well, let me ask you this. Each of the clients who email you was also a client of Eisenberg Rothweiler, isn't that correct?
Yes, and this was actually somewhat challenging because the email, as you know, went out to another 7,000. And so people were contacting me and I had to ask them who their lawyer was because I couldn't communicate with them unless they could confirm that they were represented by the ABA group.
And just so I'm clear, that last comment that you made related to the John Lucas / Tim Kosnoff communication that happened on or about November 5th. Is that what you're referring to?
Correct. My communication went out from the official committee's email. It was a mistake, and I think they've owned it. But it did go to people that it shouldn't have.
And to that end, you provided them with the list that the email went out to, is that correct?
I had provided them a list, perhaps a month before, because they were putting on town halls that were substantive and helpful, discussing the plan and how to vote. And I believed that my clients would benefit from joining in to those town halls. So I provided the email list that I got from Andrew, and I provided it to John Lucas, and he asked me if he had permission to send out the notice. And every week he did that. He came back to me and asked me for my express permission, and I granted it.
And just to be clear, you never asked Eisenberg Rothweiler for permission to send that list to the Stang firm. Is that correct?
As I testified earlier, I haven't communicated with the Eisenberg Rothweiler law firm since last December.
And I understand that. I just wanted the record to be crystal clear that there was not a communication, there was not an ask made before that list was sent to the TCC. Is that correct?
That's correct. Nor I should add that nor was I asked for my permission for them to send emails to our clients to attend the Thursday coalition town halls. So I guess there was an implicit understanding that what was good for the goose was good for the gander.
Understood. Thank you. If I could, I want to direct your attention to some testimony much earlier in the day, wherein you testified about the underlying agreement. And I don't mean the retention agreement with the client. I mean the underlying agreement between the AIS firms. Okay, I want to direct your attention to that. You testified that effectively Andrew was out front doing the intakes, and then your firm and Eisenberg Rothweiler were outlaying money for the advertising. Is that a fair characterization?
Well, it's incomplete, but it's fair.
And how is it incomplete?
Well, we were doing a lot more than just giving money to run television ads. I had as much experience.
Could I just ask you to clarify who we is? You said we were doing a lot more. I just want to be clear.
Yeah, Stewart, who had litigated civil sexual abuse claims for many years. I respected him because he lost a lot, but he kept trying. And he had a wealth of experience. He was very knowledgeable in the law in Pennsylvania and in New Jersey, where he was licensed. And of course, I had a lot of experience doing this. And so Stewart and I had many sessions where we discussed statute of limitations, defenses to statute of limitations, states that were likely to open up, communications with other lawyers who were litigating in some of these states. He was tracking cases as they moved through the appellate pipeline in Pennsylvania, which were very important. So there was a lot of experience and joint wisdom and judgment that Andrew didn't have because he was a young guy with no experience in this area. So we had a good team going.
I think you were asked whether there was any writings relative to the agreement between the three firms at the outset. And I think your testimony was that there was probably a series of emails. Is that your understanding?
Well, you know, I have to assume that we must have referenced it in some way. I can't think specifically of any emails, but I think there was an understanding, of course, of conduct of how we would operate. I operate on the basis of good faith and trust and fair dealing. And I think if you have to write up a 10-page contract with a lawyer, then maybe you shouldn't be associating with that lawyer.
Okay. With regard to your testimony about the completion of proof of claims just immediately prior to the bar date, you testified about how Eisenberg Rothweiler expanded their staff significantly. Can you articulate for me what you meant by that?
Sure. I don't know how many lawyers they have now or how many they had then, but in addition to Ken and Stuart and Josh, Fred Eisenberger, Stuart's brother, good lawyer, had a chance to work with him, met with some of his other partners briefly, but this is I believe 100% contingency law firm in Philadelphia, and these were sharp lawyers. And so when it came to the point where we were running out of time and we needed proofs of claim to be reviewed and signed by an attorney, it had been me and Andrew and Josh and Stuart, and we looked at the situation. Rita was upset, and I said, "Well, look, you've got all these lawyers in this law firm. Bring them in. You know, work on weekends." They had to give Rita more help. I don't know how many additional associates, not associates, but legal assistants that they brought in. But yeah, they had to beef up just to handle the volume of claims that had to be reviewed, processed, vetted to the best we could until we were running out of time to do a thorough vetting. But yeah, they stepped up and got the job done at a critical point.
Do you know how many staff they brought on at that point to help get the work done?
Well, in our team meetings, it was just Rita, since she was heading up. But Stuart, he said, we're bringing people in, we're bringing in relatives, we're bringing in, I mean, they were bringing in everybody that they could to process these proofs of claim so that they'd be ready to be reviewed and signed. And I don't know, maybe they expanded from a team of 4 to maybe 10 or 15. It was a significant expansion. These were temporary contract workers and so forth. But yeah, they did what needed to be done.
And do you know, did your firm hire any additional staff or anything to get that goal accomplished before the bar date?
Well, that was not my role. That was the role of the Eisenberg firm, and it was the role of Andrew Van Arsdale. I had dismantled my law firm, and I didn't, well, it's not that I didn't see the need. When I first approached Stuart about the task of handling cases, I didn't know if we were dealing with maybe 300 potential cases or 3,000, but he said that, their firm had the flexibility to expand as needed to handle that number. None of us expected 17,000, but that's what happened.
Okay. And just so the record's clear, what was your role at this point?
Well, I was sort of, I guess, senior reviewer of the client intake summaries, and from the very beginning, and they would come to me from Andrew's staff, and I would plod through them, and it was illuminating. I learned a lot about this case and the nature of the claims, and I was really astonished at a few things that I hadn't completely understood until I examined summaries in this volume. And what I mean by that is men from age 7 to 94 were relating experiences, circumstances, locations, patterns that were differentiated by decades in time, thousands of miles apart. And yet a man abused at a camp in Florida is describing something so similar to so many others who were abused in other states in different decades and so forth. So I pointed out, really kind of in amazement, how cross-corroborating these summaries were. That was one thing. The other thing was that with all of these claims, there were very few that named a common perpetrator. And we know from crime statistics that a pedophile has on average 100 victims over a lifetime of offending, which means that these 15,000 clients, and not all of them were able to fully identify the name of the scoutmaster, were really just the one of potentially 10 or 15 or 20 or 30 victims that never came forward. And so in my mind, that confirmed what I had long believed, which is that millions of boys were abused in this organization. And I had been saying that publicly for about 15 years, and I was ridiculed as being bombastic, exaggerating. And so on one level, I guess I was gratified to have been proven true. And nobody in this bankruptcy case, the bankruptcy lawyers, seemed to be able to wrap their brains around 84,000. What that means. And the responsibility that all the bankruptcy lawyers have to this entire population of victims. So yeah, I was integrally involved in the reviewing of these intakes as they came in, and noted the connections, the interrelationships, the abusers. Sometimes I'd distract myself and I'd go and try and track down this abuser, only to find that, yeah, he's still out there, and he's working in a school, or he's still out there around youth. And that was alarming.
I want to direct your attention to the testimony that you gave regarding the financing. There was an exhibit that you looked at that's part of your production that is an unsigned finance agreement that has Eisenberg Rothweiler's name on it. You familiar with that document?
I am.
You don't have a signed version of that agreement, do you?
No, and I don't know that they actually signed it.
So you testified, though, that you had reason to believe that Eisenberg Rothweiler had engaged in some financing. And I'd like to explore what your reason to believe is.
Well, about the time that I left, Eisenberg Rothweiler could not sign that financing agreement because they had already pledged as collateral their interest in future fees in their clients' cases, which included their interest in these Boy Scout cases.
And how do you know that?
Stuart and I talked about it. And so he said, you know, I'm working with my banker. I think we can straighten this out. And, you know, it was a wrinkle because he was essentially pledging security to two different lenders. And I don't know how that worked out.
You don't know that it ever happened then?
I don't.
I want to draw your attention to the time when you left the TCC before you left the coalition. Isn't that correct?
Yes, we all did.
When you say we all did, you mean all of the AIS law firms left the TCC? Is that what you mean by that statement?
Yes, and Zuckerman Spader, who represented 1,700 clients, Slater, Shulman, Andrews and Thornton. Yeah, I guess that's it.
Right. And then subsequent to that, you and Andrew left the coalition. Is that correct?
Yes.
And that was sometime in September of, I believe you said 2020.
Yes.
And the reason you stated was there was a difference in goals with the coalition, right? And you stated that your goals were to maximize financial recovery and to deliver a measure of justice. Is that correct? Were those your stated goals?
Yeah, in a general sense, but it wasn't my strategy exactly.
Okay. And were those the stated goals of the other members of AIS at that time?
Well, when we talked, you know, I thought, you know, we shared those goals and they made sounds like they agreed and shared those goals as well.
Okay, so then you essentially had a breakup effectively with Ken at some point, not shortly thereafter, as you've testified, where you were concerned about the conduct of Ken. These are your words, quote, the conduct of Ken and the credibility of Ken. Those are words that you used earlier today.
Yes.
Could you elaborate on what you mean by the conduct of Ken?
I'll just object to the form.
Okay.
And just to set the record right, we're talking about the fall of 2020 at this point, correct?
Right. I had concerns about Ken in 2018, before this ever even happened. And I can go into that, but it basically had to do with a case that I brought into Eisenberg Rothweiler. This was a family, a mother and three sons in their teens who had been horribly molested. And Pennsylvania had jurisdiction. It was in statute. I brought it to Stuart. They agreed to take the case. I had been working with the family for over a year. They trusted me. We arranged for them to come down from where they were living in New York to the offices of Eisenberg Rothweiler for a meeting. I had met with them in New York multiple times, but they hadn't met the Eisenberg Rothweiler firm that was now co-counsel. And they arrived before I did. I think I was en route from somewhere. And I got a phone call from the mother, who was in tears and very upset, as were her sons. And she related to me that she went in to a meeting in Ken's office and he started drilling her. And she said, well, Mr. Kosnoff said this: "Oh, you can't listen to Mr. Kosnoff. He doesn't know what he's talking about. Do you know how many cases, big cases I've won here? I know how to do this case, not Mr. Kosnoff." And he proceeded to denigrate me in front of my clients. I didn't know that Ken Rothweiler had inserted himself into this case. I was working with Stuart Eisenberg and Josh Schwartz. So I called Josh and I grilled him, and he was afraid to say anything. And I called Ken and emailed him and told him what my clients had told me. And he said, "I never said that. They're lying. They're making that up. No, nothing like that ever happened." And in a series of emails, I said, "Ken, you're lying. I believe them. I don't believe you." So the clients were so upset that they wanted me to dissociate their case from Eisenberg Rothweiler. And Stuart didn't want that. And I said, "You get rid of Ken, or I'm taking this case and we're going to associate with another law firm." So as I understand it, as it was related to me by Stuart later, he said they had an emergency meeting of the partners and they agreed that Ken should have no involvement in the case. And Stuart assured me that he could control Ken, that Ken was afraid of him. And he said, "I run this firm. I'm going to bring in my brother Fred, and we're going to get this case done, and we're going to get a good resolution for these clients." And I said, "Okay, fine." And we proceeded. Josh and Fred and Stuart and I obtained a very favorable recovery for this family. Ken had no part in it. So that was one incident. I was also cognizant of the fact that there was a man who was suing Eisenberg Rothweiler for malpractice because he was a quadriplegic, severely injured in some kind of gymnastic accident. And it went to a jury trial. And at a point in the jury trial, there was a $9 million settlement that was made. Ken never communicated that to this gravely injured man, proceeded to go to trial, and got defensed. Zero for this man. Now, there was an article that appeared about this man and his lawsuit against Eisenberg Rothweiler. I assume it was resolved out of court. I don't know what the final ending was there, but this was reminiscent of my experience with Ken. And then later on, Ken would frequently brag about the fact that he was a legal commentator for Fox News in Philadelphia. And he got fired after having been on the air for many years. And he wrote an email saying that the reason that he was fired was because he was too outspoken in favor of Black Lives Matter and against police brutality. And the manager who fired him responded to his email by saying, "The most alarming thing about what you wrote, Ken, is that you made it all up. We never talked about those things." So there's 3 examples. If I'm forced to dig in further, I'm sure I'll find many examples, because Ken Rothweiler is of a certain type that I've gotten to know over time, and they oftentimes end up in the legal profession, and it's a compulsive disorder. So I'll just finish with saying, no, I didn't trust him. I had a promise from Stuart that he would keep him away from the Boy Scouts case. Ken weaseled his way in. When I saw him participating in our weekly calls, I said to Stuart, we had an agreement. Ken was not to be anywhere near this case. So I made my feelings clear to him. Not long thereafter, he got back to me and he said, I understand how you feel about Ken. Trust me, I can't tell you how many times I have wanted to throw him out that window. But I can control him.
Okay, let's move on if I could.
Well,
obviously,
can I finish the answer?
Well, I believe you had.
Yeah, Mr. Kosnoff, if he wants to cut you off, he can cut you off. He just isn't going to have the benefit of the rest.
Well, there's more to the story, but go ahead.
So you testified that in early December of 2020, when Mr. Rothweiler was appointed the lead negotiator, did that upset you?
He wasn't appointed anything. Ann Andrews, as I understand it, okay, now I'm talking about a period during the coalition, so I should probably stop there. Essentially, he was put forward by members of the coalition, and he enshrouded himself in the title of lead negotiator, whatever that meant. My feelings were, this is a disaster, one, and number two, Eisenberg Rothweiler should get as far away from the coalition and those law firms as possible. And I communicated that to—
And that was your opinion, correct?
What's that?
I said that was your opinion, correct?
Well, of course, that was my opinion. But beyond that, I hadn't appointed him lead negotiator. I hadn't voted, neither had Andrew. You know, these other law firms, most of whom I didn't even know, put him up as the lead negotiator. I have no reason, I don't know, I wonder why. But regardless, I communicated, I think one last time in December with Stuart, which is, this is going to drive a wedge between our three law firms. It's a disaster waiting to happen. Don't do it. And his response to me was, I said, quit the coalition. And I got a 2-word email response, I can't. And that was the last time I've communicated with him.
Okay. I want to direct your attention to your testimony about master ballots. You were extremely concerned that there were going to be master ballots utilized in this case. Is that true?
I didn't want lawyers voting for clients. So if that's a master ballot, right, I'm against it. Each client gets a ballot, they read it, they decide, they sign it. That's what I wanted.
And in fact, as it relates to all of the AIS clients, are they in fact voting themselves?
I don't think so. Not with this e-ballot thing. I'm still investigating that.
Is the e-ballot a master ballot?
Good question. I don't know. I don't think so. What I know is they didn't get a physical ballot.
Well, didn't, in fact, the link that sent the e-ballot have a link that allowed them to request a physical ballot from Omni if they so desired?
You know, about the 4th time I read through that thing, I saw that. But judging by the hundreds of clients who didn't see it and didn't realize that if they clicked on that, they would get an electronic version of the official ballot. So I think it was largely missed. And on top of that, what if you don't have a computer or a printer and all you have is an iPhone or some smartphone? What good is that?
Well, doesn't the link say that they'll mail you one if you want?
I don't recall that.
Okay. Let me turn your attention to the October 18th letter, the infamous letter that was sent out by the TCC. Do you understand what I'm talking about?
That letter was not sent out by the TCC. It was sent out from ABA on or about October 18th or 19th.
It was initially sent out by you, however, isn't that correct?
It was my letter. It was transmitted by ABA.
And so it was transmitted to all of the AIS clients, is that correct?
That was my understanding.
It was subsequently edited by Mr. Lucas in early November, was it not?
No, it was edited for accuracy by him around October 16th, a couple days before it eventually went out.
So Mr. Lucas edited it before it went out in October when AIS sent it out. Is that correct?
Right. The letter is the letter. And it was, I sent it to him. I asked him to, tell me what he thought of it. There were some technical things that I didn't have exactly right, and I didn't want to send out a communication that wasn't accurate. And he made some important corrections to my letter. Then it went shortly thereafter to my lawyer, who made other corrections. I think he made it crisper, more readable. I don't think he altered it.
Is it fair to say that
I'm sorry, he cut off the end of his question. Answer.
I apologize.
Yeah, I think he made stylistic changes that were helpful, but I don't think he did anything substantively with the letter.
Is it fair to say that October 18th letter was a client communication?
Yeah, it said to all AIS clients.
And before you sent it to Mr. Lucas, did you caucus with the other AIS law firms to inform them that you were sending a AIS communication to the TCC for their approval before you sent it out to the AIS clients?
No, I really wasn't on speaking terms with any of them.
Now, you indicated as well that letter was edited by Mr. Wilkes, who I think you indicated took out some of the spicier language that you initially had in the letter. Is that a fair statement?
Yeah, I mean, there were some word choices that I think he, thought should be more professional.
And do you follow that same, do you send your tweets to your attorneys before you tweet out in the Twitter sphere?
Much to his regret, I do not.
What was the purpose in Mr. Lucas sending out your letter from October 18th in early November?
It was an emergency. The e-ballot.
What was the emergency?
I'm about to tell you. The e-ballot calamity was upon us. It was improper, not approved by the court, terribly confusing, and I was receiving constant phone calls, texts, and emails from clients, outraged for the most part about it, or confused. I went to Mr. Lucas and I said, look at this e-ballot thing. Can you do something? Can the TCC do something? And he said, we're looking at it. I said, it can't wait. I said, I've got to get a communication out. And you have my email addresses of my clients. I thought I could possibly hire a service that could maybe do that, but I didn't think there would be time to set that up. And I thought it was imperative that a communication go out. And he said, we can send it out. And I said, good, do it.
What was the imperative? What was the time crunch that you were concerned about?
That this massive disinformation campaign in the form of this e-ballot, this electioneering all over the ballot, and then I'm hearing that it's been manipulated in such a way as to control how the vote is made and recorded. And as I've said earlier, people couldn't do it on their smartphones. Many of these people don't have computers. I was receiving all kinds of descriptions about how it was malfunctioning, how they would vote reject, and then they would get a certificate that would say that they had voted to accept. They would complete the ballot, and then when they went to hit the submit button, it wouldn't work. And then they try it again and again and again, and it still wasn't working.
Did you reach out to Andrew Van Arsdale to ask about that?
Andrew Van Arsdale claimed he didn't know anything about it. He said in that text, I didn't do it, Tim. Eisenberg Rothweiler hijacked the ballot. He denied having any involvement in it.
Did you ever get sent a link for the e-ballot?
From clients, yes.
And did you ever attempt to utilize the link to go on to the e-ballot system?
No, I just wanted to see it. And I could see that it had username and password. I mean, I probably could have opened it up and voted because the security on this thing was laughable. It was dangerous.
But you don't know that because you didn't do that. Is that right?
Right. But I received hundreds of emails from people who registered all kinds of complaints about it, not registering the proper vote, not allowing them to complete it, complaining about the blatant solicitation all over the e-ballot. The fact that what I had to say was not contained on the e-ballot, that it was one-sided, and that they were confused because they didn't understand why they were receiving a ballot. Many of them expressed that they thought that this was the court-approved ballot. So I spent most of the time—
Let me ask you this.
No, let me finish. I spent most of the time just trying to get a real ballot into their hands. So I would cut and paste, go here to Omni e-ballots and get a real ballot. I don't know what's going on with this thing. I'm sorry it's happened. I'm attempting to deal with it, but we're going to get you a real ballot to you, and you're going to get a chance to vote. And that was essentially what I was telling dozens and dozens and dozens of people for days. And still—
Okay.
Excuse me, I just want to jump in, object, and move to strike. If you're talking about attorney-client communications.
Did your October 18th email or the TCC distribution of your email and letter have other opinions or other points of view as to how people should vote on the plan, or did it just merely articulate your point of view?
No, it reflected, it was an email, and it contained links to the Eisenberg Rothweiler letter, making the case for why they were urging yes. And a little bit below that was a link to the Kosnoff October 18th letter, which was embedded. And so when they got that email, they could click on the Eisenberg Rothweiler letter, read it, and then click on the Kosnoff letter. So earlier, October, whenever that went out, October 20th, they did receive more or less a balanced opinion from 3 law firms.
Okay, let me ask, are you a big Facebook user?
No, I don't like Facebook.
Well, earlier you testified about these pictures that you saw of Mr. Rothweiler on Facebook. How did you see those?
My fiance uses Facebook somewhat, and she was kind of curious. So she looked up Ken Rothweiler, and he had a public page, and he was out there talking and bragging and showing off his lead negotiator. Here I am on this super yacht, partying with my rich friends while he's in Los Angeles in a mediation in the Boy Scout case as the lead negotiator. And then there's him in Manhattan oh, Manhattan's great. Here I am. Look at the view from this office tower where I am now. And, you know, with some really great lawyers, and we're really working hard. And I mean, just this kind of stuff where he just, I mean, it was just shocking that he would present himself that way.
Okay, let me ask, is this where your rage comes in from your Twitter accounts? Is that where you start raging against Mr. Rothweiler?
I think Mr. Rothweiler is a clear and present danger in this case. I do not like him, and I make no hesitation about telling you that. But he's got the lives of 84,000 men. He's got enormous responsibility. And these clients are looking to us. And Twitter has been a useful vehicle for me to communicate with many of these survivors. And I use snark. You know, when Ken says something stupid, puts a picture of himself on a yacht, when he goes on the Thursday night coalition town halls, where it's all him talking, yelling, providing no light, but lots of heat. So yeah, so it's not the TCC town hall, it's the Ken show. So yeah, I mock him. And he is not an advocate for the survivors. He's an advocate for himself.
And let me ask you, the rage that you articulate on Twitter towards Mr. Rothweiler, is that something that you're proud of?
Objective form. That's not a proper question. It has nothing to do with any issue before the court.
Well, let me ask you this. Let me ask you this then, sir. Are there any tweets that you've posted that you've since taken down that relate to Mr. Rothweiler?
Possibly, I can't recall. But to answer your previous question,
He withdrew that question. He withdrew that question.
Okay.
No, he can answer it if he cares to.
Question is withdrawn. There's not a question pending. Move to the next question, please.
Is everything that you say on Twitter truthful?
Everything I say is truthful.
Everything you say is truthful. Is that what you said? You broke up. I wanted to be clear. I understood that.
Yeah, I'm a publisher when I'm on Twitter. And I believe that I have the right under the First Amendment to make fair comment on public figures, of which Mr. Rothweiler is one, and other people who I believe do not have the best interests of the sexual abuse survivors, in this case, at heart. So I make no apologies for going after people who hold themselves out as champions of sexual abuse survivors in this case.
Okay, I just have a few more questions for you, Mr. Kosnoff. I appreciate you taking the time. You testified during the examination regarding the execution of POCs that you utilized the document. I think you referred to it as DocuSign. You remember that?
Well, that was what Eisenberg and AVA used and sent to me.
Okay, if I told you that the program was EverSign, would that bother you if I said that was the name of the program as opposed to DocuSign?
Perhaps. I mean, if it sounds like it's more or less the same thing, maybe I am I used generic DocuSign because that's the one that's most widely used. But if it's EverSign, could be.
Okay, thank you.
While Mr. Hogue is looking at his notes, Karen, are you holding up okay? It's been another, I don't know, 45 minutes or so.
I have nothing further. I'm done.
So I'll repeat that question. Karen, are you holding up okay, or would you like to take a break before Mr. Gray asks what I hope are very few questions?
We can keep going.
All right. Mr.
Thank
Kosnoff, you okay?
Yes.
Thank you.
Thanks, Mr. Kosnoff. My name's Joseph Gray. I'm from a law firm in Wilmington called Cross and Simon, and we're working with the AVA Law Group in this case.
Nice to meet you.
Nice to meet you too, sir. My questions all revolve around these waivers. And just to recap a bit, Mr. Patterson asked you about some emails. They were marked highly confidential, and that part of the record was sealed. And in these emails, you had, I think you called it boilerplate, request to the clients to waive the attorney-client privilege, and they agreed to it, or they responded the way they did. Do you recall that testimony?
Yes.
And now those emails, are they the sum total of your communications with those clients about waiving privileges?
Yes, I believe so.
Okay, so there's no other conversations you would have had advising them about waiving the privilege?
There were a couple of people that had initially said, fine, I waive. And then they emailed back and said they thought about it some more and they weren't so sure. And I said, that's fine. We won't use it. And I didn't.
Okay. Now, any of these clients that you say waive the privilege, are, to your knowledge, are any of them attorneys?
I don't know.
Okay. And other than the waivers in these emails, you've testified a lot about conversations you've been having with claimants, with your clients. Did you get waivers for all those conversations?
No, because it wasn't my intention to make those things public. I thought that these.
Thank you. That's all of my questions. Just need a yes or no on that. Appreciate your time, sir. And I told you I would be short.
You're welcome.
But before we, is there anyone else asking questions today?
No questions from me, but I do want to designate the transcript at the end, Mr. Patterson.
Cameron, I'm sorry, what you want to designate what?
So we'll make a designation of the transcript at the end of the deposition.
So then, just before we get to that, we have an open issue with regard to when Mr. Hogan and Mr. Gray, you'll bring your motion for protective order. It's letter form, I believe, in the court. So I'm asking whether you could bring that motion by letter by Wednesday.
You can ask, but until I discuss it with my client, I'm not at liberty to make that agreement. And so now I'm not ready to make that agreement at this point.
Yeah, Mr. Patterson, we'll get back to you as quickly as we can, but I
We
just
will.
not in a position to do it now.
Okay.
Okay, we're
If
finished.
there's not an acceptable resolution of that, then we'll figure out how best to proceed.
Understand your position.
Okay, so the coalition designates the transcript as highly confidential under the protective order subject to our review.
Okay. So my understanding is no one else has any other questions this evening. What is on the East Coast is evening. Mr. Kosnoff obviously is set for more than the limitation of 7 hours. He's happy to do that. Folks want to continue the deposition. I know Mr. Scavone does. there's not been an agreement on when the court might have something before it. Therefore, I think we can all agree, well, tell me if anyone disagrees that this deposition, if it is continued, it will take place more than 5 days from now. Is there anyone who disagrees with that?
No.
That's fine with me.
All right. Thank you.
Okay, and if we're all in agreement, we can go off the video record and close out today's proceedings at 5:09 PM.